Good morning. Welcome in here to Murder Church, everybody. Appreciate everybody hanging out early in the morning on a Sunday. Please share this out and let folks know that you are hanging out at Murder Church this morning, and we're about to come at you.
Kevorkian adapted a mechanism whereby a string was put around the index finger of Thomas Hyde, and that all Thomas Hyde needed to do when he was ready to die was move his finger, pull the string, and that could start the flow of gas. The gas itself was turned on, not by Thomas Hyde, but by Jack Kevorkian.
Let's rock.
Ladies and gentlemen, welcome to Murder Church, Sunday morning, 9 a.m. We in here. We in this thing. Thank you very much. Holy crap. Well, everybody already hanging out. Thank y'all so much. Appreciate it. I seen Lakota come through here, and it's already out of my chat. Hold on, I think I can put up my fan funding. Yes, I can still hit her. Boom, Lakota, first of all, that's not working. Hold on. Let's turn this on. Lordy. Look who's turning 40. Not me. Lakota. What the fuck? There it is. Boom. Not only did she become a new member, who's been a member before, Lakota, the best, also gifted out a membership, but I don't know who that was for. I can't see who actually got that. I can see the fan funding, but not the actual gifting. Because it was so early on. But Lakota, thank you so much. And whoever is new, welcome to the party, pal.
Welcome to the party, pal.
Love it. And then also I see Jay coming through here as well. My man, my dad, my father, my brother from another mother. Coming through and gifting out a membership as well. Boom. Thank you, first of all, Jay. Appreciate the shit out of that. And Joni B gonna grab that thing up. Let's go. Beers in the chat early on. Let's go ahead and get a Sunday morning brewski down us, huh? Let's go. Yes. We doing it. I see so many names. Oh my God. Shannon's up in here this morning. Let's go, baby. Oh my God. This is awesome. Jersey Jen, I am not T-Pain, Charlotte. Dilly Pickles, Donnie coming through here. Amanda, Tina, Julia, Turanova, Lily Polly, lots of new names in here as well. Welcome. If you're new to Publicly Buzzed, if you're new to Murder Church, thank you for being here. That's awesome. And it's Donnie's birthday. Happy birthday, brother. Holy crap. We got it going. Let's go, baby. Let's freaking go. Donnie, happy birthday, man. I hope you have a good one. Wow. We are in week 3 of Murder Church, the Dr. Kevorkian trial. So much is going on, guys. Yesterday, and anybody that watched Murder Church Friday with Jay and me knows that I've been kind of, I found this Bryce Rhodes trial, and it's going to be starting, I believe, tomorrow. I just seen Dizzy's message also. I got Dizzy kind of looking into this as well. I'm going to be on top of this one. This one's got me. So hopefully this week, after work, Jay suggested this, maybe, doing a revamp that night of the trial, something, let people know what's happening. So I'm going to try my best to do that this week. I did make a video. I'm actually about to hopefully finish that as soon as this episode right here ends. I'm very close. I worked like 8 hours on this yesterday, but it's a pretty good video. I think I took a lot of different clips from this guy, and you kind of see why exactly he could end up in a shock cuff. He is belligerent. He endlessly fights the judge and the court and his own defense team. He actually won't speak to his defense team. The man currently representing him, he hasn't spoken to in years. Okay, they're on non-speaking terms. Okay, this guy is something else. So please, first of all, keep an eye out. Make sure all notifications are turned on today, because when that video drops, you're going to want to check it out. I'm going to have that thing dropping today, folks. So please check that out. It'll get you up to date. And again, it'll give you a vision exactly why this individual could potentially be wearing something called a shock cuff during the trial. But yeah, man. Woo! Starting out hot again, everybody, baby. Kelly Hill, you're not late. You're just on time, baby. You're just on time. Brooklyn coming through here. Love to see it. Has anybody seen Viv? I want Viv to hear the bells. Murch Church, everybody starts out with the bells. Once the bells sound, Murch Church may officially commence. I'm going to do it, and sometimes the bells actually lure Viv in here. So let's see if that's what happens this morning, folks. Let's see. Hottest new item in the Publicly Buzzed merch shop is the Murch Church beanie. That thing is flying off the shelves. Everybody that's come through and purchased one of those, thank you so much. I actually got one upstairs. I should have worn that down here instead of this hat. I've been wearing that every day outside into work and stuff. It's fucking my favorite piece of merch currently right now, actually. But yeah, we're about to rock and roll here. We're going into, again, week 3, Michigan versus Kevorkian. This is from the 1994 trial. Hopefully everyone is caught up on this. Hopefully everyone's got their notebooks as well. Detroit police officer Lonnie Lane, an evidence technician, takes the stand, followed by Officer John Green. This hour is 1 hour and 14 minutes, and we're going to jump in here. I will be kind of hanging out just to the side. I went and got a gravy and biscuit from Hardee's. I'm going to munch on that just real quick. And I made it just in time, too. I'm usually a little bit late when I do that, but it wasn't too bad. It wasn't too bad. Love you guys. Let's go. Let's rock and roll. Oh, I knew it. I knew the bells would bring Viv in here. Viv, I just rang the bells, and I'm going to do it again. Just for you, baby. Yes. Yes, ma'am. Please hit that like, guys. Please share this out. I just posted on X. Please repost that. If you repost that, that means the world to me. That can get more eyes on the possibility of people seeing what we're doing here, which is growing a revolution. Growing a revolution of kind-hearted individuals that look at true crime in a different aspect, okay? We're a little bit different over here. Let's go, baby. Let's go. First, I want to make sure the sound is working properly. Oh, man. Okay, so Saturday, December 23rd, Justifice is going to be happening, folks. And I just learned yesterday, me, Dan, and Chris Stewart are going to be on, I think, 5 p.m. that day with Jay. And I'm not sure what we're doing. I'm not sure what we're watching yet, but I'm freaking excited about that. So keep that fresh in your minds as well, folks. And it's for good cause. They're raising money. I think it's for a food bank in Rhode Island. Just incredible stuff that Jay's doing all the time, man. It's going to be pretty cool. It's going to be really good. But yeah, let's rock and roll, guys. Dude, it's going to be good stuff. I'm excited, brother. I'm excited. Love it, guys. Let's go.
Please tell us your full name and your present occupation.
Lonnie Lane, and I'm presently...
I will just preference this. Last week was very rough on here, guys. I don't think this week's going to be that rough. The subject matter on this, of course, is very, very... it's a lot. It can be a lot. Last week, we watched a video, that showed an individual that did want to have the assisted suicide by Dr. Kevorkian. He's in the last moments of Lou Gehrig's disease, which is, an absolutely horrible horrible disease that, basically shuts down all of your muscles while your brain is still fully functional. And a lot of these folks I'm just learning about this disease really. I knew about it, but I didn't know how bad it really was. A lot of these people end up, fearing choking to death because the muscles, that allow you to swallow aren't really even firing or working properly anymore. So it's horrible. But yeah, trigger warning on anything like that. If you need to take a mental health break, completely understand. I had to as well at times, so.
Assigned to the Detroit Police Department as a police officer.
Do you have any specific assignment with the police department?
Yes, I'm working at
Long Island. Did I say Rhode Island? Son of a bitch. Long Island is what I meant. My bad.
as an evidence technician with the crime lab.
Would you tell the jury, please, what does an evidence technician do?
My job as an evidence technician is to document crime scenes, and we do so by photographs, scene search, sketch, collection, preservation of evidence, and presenting the evidence in court.
How long have you been doing that, Officer Lane?
A little over 7 years now.
Could you tell us, please, were you performing evidence technician duties back on Wednesday, August the 4th, 1993?
Yes, I was.
On that date, did you have an opportunity to go to the Detroit Police Department Harbor Master Station?
Yes, I did.
Where's the Harbor Master Station?
It's on Belle Isle.
Could you tell the jury, please, where's the Harbor Master Station located in relation to the zoo that's on Belle Isle? Do you know?
The Harbor Master Station is located on Enselrue, and the zoo is located on Central. And the zoo is located southeast of the Harbor Master Station.
Now, are you familiar at all with Belle Isle in anything?
One more thing, and I just what's on my brain here. Not only did Michelle H., not only has she been here for 5 months as a member, a Buzzkiller member. Holy crap. That's amazing. Wow. Just going to hit you with it because that's absolutely cool as hell.
Happy anniversary.
Members on YouTube, keep your eye out probably tomorrow. I'm going to say tomorrow just because I'm working on the Bryce Rhodes thing today. I'm going to get the first ever, so on Patreon, I dropped, earlier this week, I dropped the first ever thing me and Dan ever did on the internet under the banner Publicly Buzzed. And that video, the first part of a 4-part series, which is really just a movie of us watching, and I broke it into 4 parts. That's how it originally aired as well, will be coming to the members only. All members on Publicly Buzzed will be getting that on YouTube probably tomorrow. So keep an eye out for that. And then part 2 of that will be dropping on Patreon a few days after that, and then so forth and so on, and we'll keep that thing rolling, baby.
Anything other than just a civilian capacity?
Yes, I am. I used to work there.
Can you give us some distance or approximate distance that the zoo is from the Harbor Master Police Station on Belle Isle?
Yes, from the rear of the Harbor Master Police Station, if you go across the park to the zoo, you're probably looking at 300 to 400 yards.
Now, on Wednesday, August the 4th, 1993, can you tell us, please, did you in fact go to the Harbor Master Station?
Yes, I did.
And was that in your capacity as an evidence technician?
Yes, it was.
Do you happen to recall about what time of the day or night that it was that you arrived at that Harbor Master Station?
Yes, I received the run to go there about 10:10 a.m., and I arrived there about 10:40 a.m., about 30 minutes later.
Could you share with the jury, please, what did you note when you arrived at the Harbor Masters?
When I arrived at the Harbor Master Station, I noticed first off a lot of news people around. Excuse me. And they had the entrance to the rear of the Harbor Master Station blocked off. I went inside the Harbor Master Station, and they directed me to the rear of the Harbor Master Station, where I met with Lieutenant Presley, who pointed out the area and the business that he wanted me to tend to.
And what business was that, sir?
There was a body in the back of a Volkswagen van.
Let me show you what has been marked as People's Exhibit Number 1 and ask you if you can identify what I've just handed you.
Yes, this is a photograph of that Volkswagen van in the rear of the Harbor Master Station that I took on that day.
At the time that you arrived and first saw...
Hold on, before I eat, actually, I want to, Joanne's in here, Joni's in here talking about, I just called her Joanne again, Joni's in here talking about my hat, so, I'm sure all women in here can know what I'm about to say, basically. So when I lose something, what do I instantly say? I'm like, Cassie, what the hell happened to this? What did you do to this? Where did you put it? What's going on? So I've been just coming at her, every day, like, you know where it's at? You know where my hat's at? I know you know where it's at, and they're hiding it. You don't like the hat. I'm being playful, but, I'm also like, where the hell's the hat? So, of course, when I found the hat, she's like, ha, interesting. Really? You found it in the area that you last had it in? I'm like, yes, that's exactly what happened. Ended up underneath a rolly chair. That's happened with like shirts in the past as well too. Like I'll lose a shirt, and I've just one of my favorite shirts ever. Like I love this movie called Hollywood Chainsaw Hookers. It's from 1988. It's a comedy horror thing. And the movie, and if I have shirts like that, I usually make them. Right? I usually actually have somebody make the shirt for me because I want a specific scene or a specific thing, so I want it custom. So this one shirt I have, which I have it again now because I fucking found it in my car after years of being buried in there. God only knows why it was just laying in there. But I was always like, where's this fucking shirt? You didn't like the Hollywood Chainsaw Hookers shirt. You didn't like the hooker on there. You didn't like the lady hanging out on there. And then you got rid of it. But no, it was also found as well as this hat. And she has never actually taken any of my clothing and hid it from me. So there's that. I'm a crazy person, guys. I had to...
Saw this van, was it secured or was it open at the time?
It was secured at the time I arrived. All doors were locked except the driver's door. The driver's window was down, excuse me, approximately about an inch, and the passenger's window was down about 2 inches.
So what action, if any, did you take when you arrived?
I spoke with Lieutenant Presley, and he instructed me to take photographs of the scene, which I did. And after I took the photographs, he opened the rear of the van, and we photographed the inside of the van where the body was. And then I continued to do a sketch of the area, including the van.
How did you open the van, if you can recall?
I recall Lieutenant Presley opening the rear door of the van with a key.
What did you see once the rear door was open?
There was the body of a white male lying face up with his head to the east, feet to the west, between two white sheets.
Let me show you what has been marked as People's Exhibit number 2 and ask you if you can identify that for us, please.
Yes, this is a photograph inside the van taken from the driver's compartment showing the body of the white male.
Does that photograph represent what that individual looked like when you first saw him, when the doors were open?
Yes, it does.
What did you do next?
After I photographed the inside of the van and did the sketch on the outside, the van was driven to the city morgue. And there the body was removed. I took some more photographs and I collected the evidence from the van.
Now, when you observed the inside of that van, when you were behind the harbor master station, did you see what's shown in photograph number 2, the what appears to be a box?
Yes, there was a brown cardboard box, and it was over the left shoulder of the body on the floor of the van. 2 sides of the box painted black, and there's a tank inside the box with a valve and a long tube that's a clear plastic tube which goes up to a face mask that is attached to the person's face over the mouth and nose.
And can you tell us, please, is that how the box was positioned when you first saw it?
Yes, it is.
As it's shown in the photograph?
Yes, sir.
Now, Officer Lane, you told us that you took some additional photographs once the body and the van were taken to the Wayne County morgue?
Yes, I did.
Can you tell us, please, did you take any photographs of the body once the sheet was removed?
Yes, I did.
By the way, when you first observed the body in the van, was there any straps or anything to fasten the body to secure it in the van?
No, there was not.
Let me show you what has been marked as People's Proposed Exhibit Number 3. Can you identify what I've just shown you, sir?
Yes, this is a photograph showing the left hand of the deceased, and it's showing a white string tied to the left index finger, and at the other end of the string is a black paper clip or a clamp.
When did you first observe the string and the clip that's shown in the photograph?
When the top sheet was removed.
Does the photograph that you have in your hand right now, People's Proposed Exhibit Number 3, fairly and accurately show what the what that clip and string position looked like when you first observed it?
Yes, it does.
Your Honor, I'd move for the admission of Proposed Exhibit 3.
Your Honor, can you just please reserve on this? I have a 403 motion on these pictures of the body, and we don't need to do that now. So, because we're not contested, I mean, Dr. Casson has already testified that there's been no marks of violence. This is a suicide, and we don't contest it. It really has very little relevance. I think we could wait until we can argue this later.
Do you have any response you want to make, Mr. Kenny?
Well, Your Honor, I do think it is relevant.
But I mean, in terms of just waiting to rule on it, do you have any concern about that?
Not right at this time.
Okay, well, I'll reserve then. Go ahead, please.
Officer Lane, can you tell us, please, when you were at the morgue, did you end up retrieving any items of physical evidence from the van itself?
Yes, I did.
Could you tell us what items those were?
Yes, I went into the van and I retrieved the string with the black clip from the left hand. I retrieved the box, the brown cardboard box, and the tank with the face mask and the clear plastic hose.
Let me show you.
Just turn it over for the time being, Mr. Lane, please, okay?
Let me show you what has been marked as Proposed Exhibit Number 6 for the people. Can you identify what I've just shown you?
Yes, on evidence tag number 037143, lists one black paper clip with a string, and I recognize this tag by my name and badge number and my assignment for that day. This is the string in the black clamp. It's been chemically treated, and I prefer not to handle it without rubber gloves.
Okay.
I believe I could probably put it here.
You recognize that, sir?
Yes, I do.
And where do you recognize it from?
This is the string and the clamp that came from the left index finger of the deceased.
I would move for the admission of proposed exhibit number 6, Your Honor.
Number 6 is in, please. Go ahead, please.
I believe you also indicated that you took into evidence some other items, a tank and tubing and whatnot.
Yes, sir, I did.
Let me show you what has been marked as people's proposed exhibit number 7. If you would take a look. What I have handed to you, and could you take a look at that and tell us whether or not you can identify what I've just shown you?
Yes, inside the brown bag is the face mask with the plastic hose and also a pressure valve.
Do you recognize those items, sir?
Yes, I do.
Hey, no, I was totally wrong too about. I haven't even looked in the chat here. We're trying to figure out an MTV show. Oddville, okay. Let me look at that one and see if that's what I'm thinking about. Because what I'm thinking about is not the actual block of entertainment that I'm thinking about was called Oddities. That I'm talking about. It had like, do you remember that cartoon, The Head, the dude with the giant head with the alien inside of it? I really want to, but I can't think of the show I'm talking about, man. It was like a talk show where they had like all kinds of like, you know, different strange type of people. Oh, that is the show I'm talking about. Oddville. Okay, it's the same show. Nice. That show was crazy. I wonder if it was 1997. I wonder if that came on the Oddities block. Cause yeah, man, it had like all kinds of crazy stuff on there. But yeah, this is totally the same show. Oddville. Nice. Yeah, dude, this show was awesome. This show just feels like the mid to late 90s. Like, dude, I really miss this era of television so much. But yeah, hell yeah. Nice.
And where do you recognize them from?
These are the items I took from the face of the deceased and from the van.
Okay. And what about the other items that are there and sitting before you?
Listed on evidence tag number 0371142 is the black tank and the brown cardboard box with the sides painted black. And also listed on this tag is the contents of the brown paper bag here in my hand.
Okay. And do you recognize those as coming from the van?
Yes, I do, and I recognize it by my name, badge number, and my assignment for the day on my evidence tag.
Okay. I'd move for the admission of proposed exhibit number 7, Your Honor.
Any objection? Okay, those are admitted.
With regards...
6 months? Whoa, can't believe it's already been half a year. Pastor Steve doing an amazing job. Wow, Disney nerd. Wow, wow, wow.
Happy anniversary. Happy anniversary.
Happy anniversary. 6 months is half a year. Half of an entire trip around the globe that you've been with us. I can't believe that, and that's freaking awesome. Thank you, thank you.
To the items on proposed exhibit 7 that you've just identified for us, did you ever take photographs of them?
Yes, I did.
Let me show you what's been marked as people's proposed exhibit number 4. Can you identify what's shown in that photograph?
Yes, sir. This is a photograph showing the black tank with the pressure valve, along with the evidence tag and the round cardboard box.
Does that fairly and accurately depict what they looked like at the time that you first examined them?
Yes, it does. And this photograph was taken at the police crime lab after I conveyed the evidence to our laser unit over there.
Laser unit. Laser unit.
I'd move for the admission of proposed exhibit number 4, Your Honor.
Number 4, any objection to that, Mr. Schweigel?
Is that the?
Yeah.
No objection.
Okay, that's admitted then.
With regards to the tank on exhibit number that's shown in exhibit number 7, as well as the photograph number 4, were there any kind of identifying marks or numbers on that?
I didn't examine the equipment that close. I was preserving it for fingerprints.
Okay. Thank you, Your Honor. At this time, I have nothing further.
Mr. Fanger?
Thank you very much. Just a few questions. When you observed Mr. Hyde in the van, did he appear to be suffering?
No, sir.
You indicated that you saw attached to his finger a string which led to a clip. Is that correct?
That's correct.
And it was your understanding, was it not, that the clip was for the purpose of pinching the plastic tubing at some point, and that Mr. Hyde at some point pulled the clip off to allow the plastic tubing to expand and fill with air and gas?
Yes, that was my understanding.
And therefore, had Mr. Hyde not pulled that clip, which crimped the plastic tubing, allowing air and gas to flow into the mask, he wouldn't have passed away, correct?
Assuming the clip was on the tube, and assuming the clip was strong enough to cut the flow of air or whatever off, and assuming no one else took this away, yes, that would be correct.
That appeared to be what the purpose of the clip was, to allow and the string attached to his finger, to allow Mr. Hyde the ability to make a decision regarding whether or not he wanted his suffering to end,
Well,
correct?
I object to that, Your Honor.
The phrasing of that question, I would sustain the objection. If you want to try to rephrase that, you may.
Sure. The purpose of the string and the clip attached to the tubing appeared to allow Mr. Hyde the ability to decide whether or not he was going to pull it, correct?
Correct.
How long have you been with the force?
24 years plus.
And in your particular position as an evidence technician?
Yes, sir.
How long?
A little over 7 years.
Okay. Do you investigate all deaths?
We investigate not all deaths. Some of the natural deaths, I'm sure they turn over to the Wayne County medical examiners or the family, depending on conditions, situation, age, medical conditions, and that sort of thing.
How about suicides?
Yes, we do.
When is, and do you do all this crime lab stuff on suicides and preserve evidence?
Yeah, yes, we do.
When's the last time you testified in trial in a case involving a suicide?
I don't recall ever testifying.
Do you recall any of your colleagues ever testifying in court regarding a suicide?
No, sir, not in criminal court.
Thank you. No further questions.
Mr. Kenny?
Have you testified in any court proceedings regarding a suicide or attempted suicide?
I don't ever recall testifying in regards to a suicide.
Okay, what about colleagues?
Perhaps civil suits.
Okay. Nothing further.
Mr.
Nothing further, Your Honor. Thank you.
Mr. Lane, thank you, sir. Watch the box there on the fall.
Thank you.
Okay.
Sir, please tell the court your full name and occupation.
John Green, Detroit Police Officer.
And what's your current assignment?
Detroit Police Harbor Master on Belle Isle.
Were you working for the Harbor Master back on Wednesday, August the 4th, 1993?
Yes, I was.
And on that date, do you recall what hours you were working?
7 a.m. to 3 p.m.
What was your assignment that day?
I had a staff administrative assignment within the station.
Were you there at the station at 7 a.m.?
Yes, sir, I was.
And can you tell us, please, did there come a time when you left the station to perform any police duties?
Yes, approximately 9:30 in the morning.
And what caused you to leave at that time, sir?
Mr. Feiger came into the station and stated that he had received a phone call from his client, and his client wanted to meet him at the zoo area.
Where's the zoo in relation to the Harbor Master Station?
It's approximately 1/4 mile east of the station.
And did you then leave the Harbor Master Station?
Yes, myself and Inspector Arthurs left the station. We went into the parking lot to get into a vehicle where we encountered Police Officer Anita Banks.
Okay. What happened then?
Inspector Arthurs directed me to apprise Officer Banks as to what had transpired inside. I did so, at which point Officer Banks offered that she had seen the van approximately.
Objection, hearsay.
Your response to that, Mr. Kenny?
That's fine.
Okay, I sustain that, please. Go ahead.
So you had some conversation with Officer Banks, and as a result, after that conversation was over, where did you go?
To the area of the zoo, which is Central and Vista.
Okay. And do you recall what happened at that point?
We were looking for a white Volkswagen van. We checked the area for a minute or so. There was no van in sight.
Did you eventually see a white Volkswagen van?
Yes, yes, we did. The van was on an adjacent street, Riverbank, proceeding west from Vista.
And when you say it would be heading west, it would be heading in which direction? Toward what?
Towards the Harbor Master Station, Belle Isle Bridge.
Okay. Was that vehicle pulled over?
Yes, we pulled the vehicle over alongside the Harbor Master Station on Riverbank.
Can you tell us, please, did you see who was driving the vehicle, the van?
Yes, Dr. Kevorkian was driving the van.
The gentleman in the blue sweater and cream-colored jacket?
Yes, sir.
Okay. Now, before you
Thanks,
had
Bobby.
been out on
Good to see you.
the street on Riverbank, had you seen Dr. Kevorkian at the station earlier?
No, sir.
And you said you had been present there since 7 a.m.?
That's correct.
Okay. Thank you, sir. I have nothing further at this
Mr.
time.
Hyde.
Thank you, nothing.
Thank you, Mr. Green. You may be excused. In the jury there, we need some time to prepare for the next witness and get that set up. So rather than have you just sit here and wait, we're going to just take a few minutes to get that all ready. So I'm going to excuse you. You may take a short break if you want to go get, some refreshment or something. You may do that. So let's look at approximately 15 minutes to be back in your jury room. Maybe by then we'll be ready. Okay, may be seated. Do you want to raise the issue regarding, it's just the one photograph that we're talking about now that you had in?
Your Honor, thank you very much, Your Honor. I had indicated earlier that I had Mr. Kenny had not sought admission of exhibit
3, is it?
Oh, I think 2 is over.
No. 2 and 3 are the ones that I had objection to.
I think that we already, you already agreed to admit number 2, Mr. Feiger, last week, because I remember
I don't recall number 2.
Jury, yeah.
Isn't number 2 is the
It's 2 is what is 2 now?
a picture of Mr. Hyde's body in the van? I had thought last week that I agreed to the van and the scene of the zoo, which are 5 and 1.
No, my notes indicate, that you did not object to the admission of number 2, and that
Number
I
2
believe
last week.
number 2 was in fact published before the jury. Was it not?
Yes.
This has already been published?
Yes.
See, I thought he was talking about 1 and 5, but if in that case, Your Honor, I just withdraw the objection, and the 3 can go in.
Okay, very well then. 3 will be in also. All right.
Thank you.
We'll wait until. Let me know when you're ready. Okay. Please remain seated. We're back on record before we bring the jury in. I understand that's something we want to say.
Yes, Your Honor. There is a matter I'd like to bring to the court's attention, if I may. If the court will recall, at the opening statement made by the defense, there was a reference made by Mr. Feiger that the assisted suicide did not take place in Wayne County in the city of Detroit, but rather that it occurred in Oakland County. Your Honor, at this particular time, I am going to request the opportunity of the court to allow me, once I finish with my witnesses, to present an additional witness, that being Robert Ianni, who is the head of the criminal division of the Attorney General's office. I have the original document right now. I'm handing a copy to Mr. Feiger, a copy of an order that's dated April the 22nd, 1994, signed by Frank J. Kelly, the Attorney General of the State of Michigan, that pursuant to MCLA 762.3 designates the County of Wayne, State of Michigan, as the county in which the perpetrator of said felony shall be prosecuted and punished, along with a copy of the people's petition to the Attorney General pursuant to MCLA.
I don't have a copy of that petition. That had to have been done ex parte because nothing was ever given to me. So I don't have it. You didn't hand me a copy of that.
I just have the one copy, Your Honor. I will have copies that I will gladly make
Give
available.
it to the deputy. She will get a copy made of that. Okay.
I always like that in the trials. It's like, well, I never actually got a copy of that. And then the other dude's like, well, I have it right here in my hand, but you're supposed to give it to the other dude. You should have a copy as well. But I have it right here, Judge. And you do too. I don't know what he's talking about not having it. You know, I know that he doesn't have it, but I have it right now in my hand. Currently, I'm right.
Your Honor, I would direct the court's attention to MCLA 762.3, which does in fact provide that the Michigan Attorney General can in fact make a designation. 762.3 indicates that if it appears to the Attorney General that a felony has been committed within the...
I don't like this fucking guy because he's coming after Dr. K. Okay? He's coming after Dr. Death, Dr. Kevorkian.
State, and that it is impossible to determine within which county it occurred. The offense may be alleged in the indictment to have been committed and may be prosecuted and punished in such county as the Attorney General designates. It goes on to talk about the state bearing the burden, or the county bearing the burden of that particular expense. Your Honor, I would submit to the court at this point a copy of the petition and the order just as an offer of proof. Mr. Ianni will be available to testify regarding the authenticity and the proper legal foundation for the admissibility of that document if it is so requested. Your Honor, the statute 762.3 does not address the issue of when this designation must take place. And with regards to that, I would like to call the court's attention to the fact that over the weekend I was able to find that in Oakland County, in 1986, in a case of the people of the state of Michigan versus Victor King Malone, was a murder case in which a...
Objection. This court has already indicated that decisions in other circuit courts of the state are not applicable to this court. You've so found in my request for collateral estoppel that the decisions of Judge Kaufman and Cooper do not apply to this prosecution. So to suggest that there's been another circuit court judge somewhere on some facts that don't even relate to my client as somehow having any influence on this court is just contrary to this court's previous rulings.
Well, I don't even know that's what he's going to say, Mr. Feiger. Give him a chance at least to make his record, and then you can get a chance to respond to that. Please go ahead.
Yes, Your Honor, in the case of Victor King Malone, it was a murder case where the body was found in Southfield. There was a question as the case progressed as to exactly where the murder took place, and that there was some inability to determine whether or not the murder took place in the city of Southfield where the body was found, or whether the body had been, or whether the individual had been killed elsewhere, specifically the city of Detroit, and that the body had been dumped there. In the middle of the prosecution's proofs, the prosecutor for Oakland County sought and obtained a designation of Oakland County as the jurisdiction, and that designation was obtained by the Attorney General's office pursuant to the same statute that we're relying on. There was an objection by the defense. The case went on to trial. The defendant was in fact convicted. There were in fact post-conviction motions that were brought. I have been supplied with a copy of the opinion of that trial court and the motion for relief of judgment. The issue about venue was in fact raised. The court in the motion for relief from judgment denied the defense request for a new trial. The case went then up to the Michigan Court of Appeals, and I have a copy and copies for the defense as well, where the Michigan Court of Appeals ordered that the delayed application for leave to appeal was denied for lack of merit in the grounds presented. So while there is no specific case law that we could find dealing with the issue of a request and an obtaining of a designation once the trial had been started, I do believe that the Victor King Malone case does provide some guidance to the court, certainly not binding, but some guidance. I would also like the court to consider this, which we believe is an analogous situation. The court, I believe, is familiar with MCLA 767.76.
Before you do that, though, let me
Yes.
go back to the Victor King Malone case procedurally. At what point did that become an issue in the case? Was it prior to trial that was raised, or was it after the trial had commenced, or do you have any information as to procedurally how that came about? Did it all of a sudden come aware to the prosecution that they wasn't sure about that and they sought that? Was it anything raised by the defense?
Could I have just a moment, Your Honor, to
Okay.
clarify that?
Just for the record, Mr. Kenny's clarifying that with the Oakland County prosecutor who's been assisting him in his prosecution here.
Why do I need that for the record, Mr. Feiger?
Because, Your Honor, I mean, at this point in the proceedings, Your Honor, I'll wait and make my argument, but I think that it's highly objectionable what's going on here, and I'll state it more clearly.
Okay, I'll just let it note it for the record and leave it at that, please. Okay.
Your Honor?
Yes, sir.
It is my understanding from talking to Mr. Schiffman from the Oakland County Prosecutor's Office that the Prosecutor's Office became aware of the concern about the issue the day before trial began. However, the issue of bringing up and introducing the designation did not come until the middle of the prosecution's proofs.
Bonnie Bailey coming out here. Gonna spit a little fire with $2, passing the plate and the bowl. It's Bonnie Bailey. You are an MVP. Thank you so much. I appreciate the shit out of that. You my bad man. A little ODB, a little Biggie, and you're gonna get a little bit of Ted DiBiase also. Yeah, thank you very much. Appreciate that, Bonnie.
Okay, I just need that information, please. Go ahead. Anything else? Go ahead.
Yes, Your Honor, I would like to call the court's attention by way of analogy. The court is, I believe, familiar with MCLA 767.76, which is a statute that permits the trial court to amend the information at any time before, during, or after the trial in order to cure a variance between the information and the proofs, as long as the defendant is not prejudiced by the amendment and that the amendment doesn't charge a new crime. I think that is helpful to the court in that there is a statutory scheme whereby the court is permitted, as the trial progresses and as evidence unfolds, the court is permitted to make certain amendments. And when you look at some of the amendments that are permitted under that statute, they are a lot more dramatic than we have in this particular case. The Court of Appeals, in interpreting 767.76, when it talks about whether or not the defendant has been prejudiced, it talks about whether it's a prejudice only when the defendant does not admit his guilt and is not given an opportunity to defend against the crime. The court, I would call the court's attention to 1987 Court of Appeals case, People versus Strickland, found at 162 Michigan Appeals 623, where a defendant was charged with criminal sexual conduct in the first degree, where there were allegations of particular forms of criminal sexual conduct in the first degree. During the course of the trial, it turns out that other types of penetrations were alleged and came out in the proofs different from what had been than what had been offered. At the close of the case, the CSC1 counts were amended to conform to the proofs to reflect the different form of penetration. Court of Appeals found that there was no prejudice because the defense on the merits of the case were the same.
Okay.
Additionally, Your Honor, if I could...
Let me just interject something there. But when you're comparing what you just said about Strickland, where there were some amendment of changes to allow for some other allegations, isn't venue or the question of the status of the offense a lot more significant? It's a lot more primary because you have to be concerned about jurisdiction, about jeopardy, and a host of other possible constitutional issues that may be involved, more so than...
Amber coming through on the Buy Me a Coffee, and $10, Amber. Holy shit, thank you so much. Appreciate that. I'll put that up there for anybody that does want to donate outside of YouTube. All the different links are in there. But Amber, thank you so much. That's freaking amazing. Makes a couple up right there. Thank you so much. Appreciate that. That's awesome. I don't do a buy me a coffee. I do a buy me a beer. Buy me a brewski with that thing.
Whether or not there were some other offenses that may not have been included in the information.
Your Honor, under MCLA 600.1601, states that venue is not a jurisdictional matter. And the commentary to that particular section and that particular chapter indicates that venue is not a jurisdictional matter.
Hold on.
It is a...
Why would I not play her own song? Amber's got her own song, guys. Hold on.
Amber is the color of your energy.
What?
Right of procedural convenience enforceable by a timely objection. There is case law also, as the court may well be aware, that venue, while it is a part of the prosecution's case, is not, for example, an element of the offense. It's not one of the essential elements of the crime, and there's case law that specifically says that. So we would submit that there is there should be flexibility. We would request to...
When you say it's not an element of the crime, isn't it traditionally to instruct the jury that along with finding the elements that they also must find that the offense occurred in a certain state or city or something like that? I know I've been given that instruction for the last 12 years or so, and if I'm wrong, there's a whole lot of problems out there somewhere.
No, I grant you that. I'm just calling the court's attention to People versus Swift, which is a 1991 case from the Michigan Court of Appeals at 188, Michigan Appeals 619. And there was a situation, Your Honor, where it was a corpus delicti type of issue where the defense objected to the introduction of evidence regarding venue from the defendant's own statements before there had been any kind of independent evidence to that effect. Now, the Court of Appeals stated on page 620 of the opinion, the key words here are essential elements. Venue, although a necessary...
Hold on! What is happening? I legitimately thought it was amber is the color of your inner genie. Wow. Amber is the color of your inner genie. Whoa.
Amber is the color of your energy.
Amber is the color of your inner... I can't even say it. Amber is the color of your inner genie.
Amber is the color of your energy.
Whoa. Amber is the color of your inner genie.
Amber is the color of your energy.
I love that.
portion of the prosecution's case is not an element of the crime.
Well, let me ask this just as a matter of procedure. I want to hear all the legal arguments that need to be made on that right now. But if we look at it as something of an element, and I think that that's the way it mentioned at the beginning of the trial, that the prosecution would not be able to prove that element, and essentially, and if I have to wait.
Dude, that's nothing, man. Like, I can't even think of one right now, but any song ever that comes on the radio, if I'm singing it and Cassie's next to me, she's like, what the fuck did you just say? That's definitely not what they're saying. I'm just like, oh.
At some point at the end of the prosecution's case in chief, whether or not there is sufficient evidence for that to go before the trial of fact. And assuming that I find that there is there still a more or less a law or legal argument, to be made about this that would necessitate my making a decision prior to making any kind of ruling on whether or not the evidence is sufficient for it to go to the jury? In other words, I'm trying to read your mind perhaps, but if you are making the motion now, I'm viewing this as basically a legal argument that need to be made and somehow decided, before the prosecution's case can be, what can I say, official in a way because of that question of that jurisdiction. Is that what I'm hearing?
Well, my preference, Your Honor, would be to introduce it at this time, while I think that we could, in fact, have legal argument on a directed verdict motion where that may not be necessary. What I'm concerned about is if at the close of the defense proofs there is a renewal of that motion for directed verdict, I want to be in a position to be able to deal with that issue. That's why I'm bringing it up at this particular time.
Okay, well, see, that still doesn't answer my concern, though, Mr. Kenny. I guess, let me see if I can phrase it differently. I'm trying to ascertain whether or not there are two separate arguments, that has to be looked at, two separate procedures. One, that as a matter of law that may supersede any concerns about whether or not there is sufficient evidence on that issue, whether as a matter of law, as I said, that is more paramount than any other issue that has to be decided by this court on that. And if so, at what point does it have to be decided, and is this the point for that to be made now? I ask that because I anticipating something of this argument after last week, spent some time also over the weekend looking at some of the issues there. So I had the statute here that you mentioned and some of the cases, that are discussed there, and I had some of the same questions that I think you tried to answer here about at what point can the Attorney General make that designation. I also looked at this in terms of whether or not at some point, if that's not proved, whether or not jeopardy, has attached, and how you analyze that. Those are all factors that are out there, I think, that are raised by this issue. But I'm also wondering in terms of whether or not it's timely or not, if it's properly raised now or at the end of the prosecution's, case. I understand your response to be that even if it comes at the end of the case, your case, it still has to be decided because it's something that could be raised later on in motion for a directed verdict. Am I correct in that?
That's correct.
Okay, go ahead and finish your argument. Let me hear from Mr. Franklin.
Your Honor, I would just indicate as I have the court having had the opportunity to review the statute does not specifically preclude us from seeking and obtaining that designation once the trial begins, and we would respectfully request that we be permitted to introduce that as evidence of the designation. I would also indicate to the court that I do have copies of the transcript from the Victor King Malone trial, as well as the copies of the order for the denying the request for relief from judgment and the Court of Appeals decision. Those have been made available to me.
Well, I'm not sure what their value is other than some guidance, but I won't.
That's why I've offered them, Your Honor, recognizing that they're not binding on the court, but I think that it is illustrative of what has taken place in the past and what the response has been to it.
It would have been nice if the Court of Appeals would have responded to that, but sometimes we don't have the conveniences of that wisdom. Mr. Feiger, your response, please.
Yes, Your Honor. The prosecution has now made a motion alleging that they are unable, at the close of their proofs, after a jury has been selected, after the information has been read, after we have proceeded with this case up to and including the very conclusion of the prosecutor's proofs, the prosecutor presents us with a document which it secretly submitted to the Attorney General and immediately got a response back, which I think is significant to the court in terms of what is actually going on here. We have the Oakland County prosecutor sitting here. We have the prosecutor secretly committing or communicating with the Attorney General. We have orders out of the Attorney General issued literally overnight, and I know the court is aware of the processes of courts, and this would be virtually impossible but for a explicit now cooperation between these authorities to not only prejudice, but attempt to deprive Dr. Kevorkian of his constitutional rights, and it's incumbent upon this court to protect those rights.
Tell me what the impropriety is that you're suggesting in terms of the prosecution going to the Attorney General. I mean, that is essentially they are the, what you might say, the prosecutorial, arm of or that part of government, I guess you want to.
Well, they have secretly gone.
Yeah,
Your Honor, they allege to have made a petition. A petition in a legal proceeding must be, both sides in the court must be provided notice, because this petition alleges, and I have a copy of it, that the prosecutor is unable to prove one of the essential elements of the offense. And it's signed by John O'Hare. So we had a secret communication between the Attorney General and the prosecutor of Wayne County saying, Mr. Attorney General, during trial I have realized that I have I am unable to prove an essential element of my case, that is venue. And may I, Your Honor, Mr. Kenny wasn't being entirely forthright. As Your Honor knows, it has been the law of the state for over 100 years, and I cite People versus Riley, 45 Mishap 338, and the law is incorporated in standard jury instruction, I believe 3.10, that venue is an essential element of the prosecution's case, and I think there are perhaps 100 other cases. Now we have the prosecutor at the end of his case secretly going to the Attorney General and saying, in a secret petition, I cannot prove my case. And at the close of my proofs, Mr. Feiger is going to secure a directed verdict because I have failed to secure one of the essential elements of my claim, and so I want you secretly to issue an order, which I will go and present in front of Judge Jackson, to say that after trial began and after I realized that I have failed on one of the essential elements of my case, I want you to say it was okay. And you tell the Judge Jackson that you've now designated Wayne County, and forget about the fact that we're at the close of the prosecutor's case and that we have materially changed the theory of the case, and that Dr. Kevorkian, beyond being materially prejudiced, this would be the most outlandish prejudice ever perpetrated in Michigan law. Your Honor, this statute, to my knowledge, allowing the Attorney General to designate venue has been on the books since 1927. Never before in the history of the state of Michigan has an appellate court allowed a prosecutor, when it realized it was failing an essential element of a case, to say, well, okay, you don't have to prove that element of the case anymore because all you have to do is go to the Attorney General and he'll work with you secretly and supply a order to the circuit court. Well, as a matter of fact, the statute says something entirely different, Your Honor. The statute says that the order has to be entered before the indictment, and the indictment has to include the fact to Dr. Kevorkian or any other criminal defendant that such an order has been applied for and sought, because the statute says if it appears to the Attorney General that a felony has been committed within the state and that it is impossible to determine which county it occurred, and that is why I'm saying the petition to the Attorney General secretly admitted that they couldn't prove their case. The offense may be alleged in the indictment.
I'm sorry, just Jackson. Ooh, I am for real.
To have been committed and may be prosecuted in such county as the Attorney General designates. The offense may be alleged in the indictment. In this indictment, which Your Honor read to...
Also, right now...
I'm telling you like it is, baby.
Bam! To this defense attorney. Kevorkian got a good one.
The jury at the start of this case, there was no securing of an order before trial, and there was no knowledge of any of this. There's a felony information which alleges that the prosecutor of Wayne County has alleged that an assisted suicide occurred in the county of Wayne. This had to come before the proofs were entered. Before the information was filed and before we went to trial.
Where's the authority for that, Mr. Feiger? Where is the authority for the statement that you just made that it has to be or have to be done that way?
Because the statute says that the offense may be alleged in the indictment to have been committed and may be prosecuted in such county as the Attorney General designates. In other words, the indictment must set forth that the prosecutor is unable to prove the essential element of venue and therefore has secured an information with the cooperation of the Attorney General, and that has to be alleged in the indictment or the information. Now here the prosecutor says, we didn't comply with that form of the statute, because the statute clearly says it. We are coming to you at the close of our proofs, and we want you now to materially change the theory of our case, because we acknowledge to this court that we cannot prove where an essential element of their case. And we want you now to amend the information to, as if nunc-pro-tunc, we had done this before trial. And the rule on amendment says that no proposed amendment may unfairly surprise or prejudice a defendant, and that's why in over 70 years with this statute being on the books, Your Honor, and I might say there are numerous cases in which venue has been challenged during the proceedings, and if it was simply an issue of the prosecuting attorney going to the Attorney General before the close of his proofs and or even before the end of trial and getting an order secretly admitting that he didn't prove one of his essential elements, we would never have any cases on the prosecutor's requirement to prove venue as a element of their case, because the prosecutor, as a matter of simple logic, would never have to do it. In this case, Your Honor, the prosecutor has now put itself into an impossible bind in which this court must now find, I believe, as a matter of law, that the case against Dr. Kevorkian has got to be dismissed. The prosecutor has admitted in a letter written to the Attorney General, secretly communicated apparently on April 21st, 1994, that it has failed and it cannot prove an essential element of this case. The statute says that the prosecutor must have alleged this in the indictment and sought an order from the Attorney General prior to trial. The prosecutor now comes before the court, and I think that's the question Your Honor answered. Might I not find that this is a question of fact for the jury and submit it to the jury? I would say you could conceivably find that way, although I didn't think there was an iota of proof to substantiate it, and I would argue for a directed verdict. But that matter has now been taken out of our hands.
Whoa, uh-oh. Here we go. Let me see. Get it in the right spot here. Ashy Snow. Yeah. Get a little singing with you, Ashy. 1999. Yeah, thank you very much. Appreciate that. Appreciate that. I'm going to give you my new boy. My new boy. 1999 back in the day, not anymore. They're outrageously expensive now. But in the 90s, 1999 to me meant a wrestling pay-per-view. Okay, a WWF, a WCW pay-per-view cost $19.99 only on pay-per-view. Ashley, I love you. Thank you.
Hands by the admission of the prosecutor, which has been provided to you, admitting he doesn't have any proof of this matter.
Where's that admission, Mr. Feigl? Maybe I'm not reading the same document that you're looking at. Tell me where's
April
that admission.
21st, 1994, paragraph 3. It is impossible to determine with absolute certainty within which county, district, or political subdivision the offense occurred, Mr. O'Hare wrote to the Attorney General. And the Attorney General apparently, the very next day, suddenly comes out with an order saying in the second paragraph, Your Honor, it appears to me that the exact location of the commission of said offense in this matter cannot be determined. Now, how are we going to, where we have two law enforcement authorities admitting that they can't prove an essential element of the offense, going behind everybody's back in the middle of trial, not just in the middle, at the conclusion of the proofs, and saying we can't prove an essential element.
I love this dude, man. He's fighting so passionately for Dr. Kevorkian during this whole thing. If anybody that didn't see the openings, episode 1 with Bob Motta, go back, check it out. Amazing opening. And right now, still just continuing to fight, man.
The offense, and now we want you to not only act contrary to the statute, which says they have to allege it in the information, but they want you to amend the information now and materially and substantially prejudice Dr. Kevorkian is beyond belief. There has never been an appellate court in this state, as admitted by Mr. Kenny, which has ever sanctioned when a criminal defendant, after the impaneling of a jury, has challenged venue, and the Attorney General cannot simply alter his legal theory and admit he's gone to trial without proof of an essential element of the offense and get the court to remove his duty to prove that essential element simply by secretly going to the Attorney General. Your Honor, that's offensive.
I believe this guy's name is Jeffrey Feger, and I was kind of just looking at him here for a second. And in 2007, he had a little bit of legal issues. In August of 2007, Feger was indicted on federal campaign finance charges. The U.S. government alleged that Feger had illegally funneled $127,000 to John Edwards' 2004 presidential campaign. Feger was defended by famed defense attorney Jerry Spence, who announced this would be his last case. A jury acquitted Feger of all 10 charges, and the co-defendant and law partner Vin Johnson on all 5 charges. On June 2nd, 2008, Johnson stated that the charges were politically motivated. So he never, it was all bullshit, according to a jury who saw the evidence. So interesting.
And if you don't protect Dr. Kevorkian, as I'm sure every other criminal court has done in the 70 years of this statute, we have law enforcement officers running roughshod, not over simply Dr. Kevorkian, but now the law. Now the law. Here in this case, he's asking two things. One, he's asking to amend the information, and that would unfairly surprise and prejudice Dr. Kevorkian. Since we've selected a jury, we're going to the jury, and Dr. Kevorkian has prepared his case in part on the basis that the prosecutor will be unable to prove an essential element of the case. The prosecutor, knowing that, and knowing that Dr. Kevorkian was right, secretly went to the Attorney General and tried to circumvent the law by now claiming that we can remove an element of the prosecution's case simply by making an allegation during the middle of trial that we can't prove it, and so you designate non-pro-tunc as if it was before the trial, the venue in this case, Your Honor. I think you got to this, Your Honor, when you're questioning with Mr. Kenny. This goes to constitutional muster now. This is an attempt to undermine the entire proceedings in this case. And it involves the Oakland County prosecutor and the Attorney General, along with the Wayne County prosecutor. This is just an outrage, Your Honor. And I thought you were correctly questioning Mr. Kenny on the in fact venue being an essential element of the case, which must be proven, and the prosecutor can't simply go.
I'm looking through this gentleman's legal career and some of the cases he's dealt with, and it's just like a list of wild ones. Here's one that I'm unfamiliar with. I'm probably going to butcher the guy's last name, but the family of Scott Amadur. It's from 1999, a wrongful death and negligence suit from the Jenny Jones show. Figure was unsuccessful in representation. It was also in Michigan. And I pulled it out to the side here, and this guy appeared on the Jenny Jones show, revealing same-sex secret crush in which he admitted to being a secret admirer of Jonathan Schmitz. Until the taping, Schmitz did not know who would be revealed as his secret admirer. Schmitz stated that he participated in the show due to curiosity, and he claimed later that the producers implied that his admirer was a woman, although the producers of the show claimed that they did tell Schmitz that the admirer could be a male. I think I remember, this is kind of ringing a bell now, and then that guy freaked out and killed the dude in real life, I'm guessing. I'm going to dig in that one a little bit more. But he also represented one of the kids from the Columbine massacre. Looking at that name now. I'm not familiar with that. Okay, it was one of the victims, looks like. Another person by the name of Ralph Paints, accused of killing his ex-wife Nancy Campbell Paints in July of 2000 following their appearance on a segment on Jerry Springer. Wow. Here's one from A&E. Like, he got a lot of high-profile cases, it looks like, here.
And get the Attorney General, who we know, by the way, I might add, the Attorney General in this case is a litigant against Dr. Kevorkian presently. The Attorney General presently has pending a proceeding before the Board of Licensure in which the Attorney General is the active complainant against Dr. Kevorkian. The Attorney General, without any complaints ever having been filed against Dr. Kevorkian, sua sponte, took it upon himself to file a complaint with the Board of Licensing against Dr. Kevorkian and manufacture a case in which Dr. Kevorkian's medical license would be suspended without a hearing. Now, that is another background in this case, how and why the prosecuting attorney would be able to secretly go to the Attorney General and secure such a thing within a day and do it secretly, Your Honor. Your Honor, I'm asking at this point, I've been very impressed with the fairness that this court has shown both litigants in this case, up to and including right now. The attempt being made by the prosecutor in this case is not only unconstitutional, it is contrary to court rule, it is contrary to statute, the statutes being the prohibition of unfair prejudice or surprise in an amendment, the statute being the amendment of the venue statute had to have been alleged in the information in the very beginning, and the cooperation and plotting against Dr. Kevorkian in this case can only be protected by you in this case, Your Honor. And I ask you to deny it. This is just unbelievable that in 70 years no court has ever seen fit to do it. But in this case, suddenly the prosecutor realizes it's failed and now seeks to do something which no appellate court in this state has ever allowed.
Wait a minute, Mr. Frager. What are you saying? Are you suggesting to me or saying to me that a court of appeals or a higher court has considered this issue and has not allowed this to happen?
No, in fact, it's exactly the opposite. It is no prosecuting attorney in the history of the state has ever thought that they could get away with this, because if they could do this, then all of the cases which indicate that and I cite People versus Riley, I cite People versus Ayers, which is 182 Mish 2, is 182 Mish 242. I cite People versus Watson. That would be.
I'm not sure those cases that you have mentioned are on point with what I think is the central issue here. In spite of your comments, that this was done secretly and so forth, that this is some dastardly deed, by the prosecution, I'm not sure that the process, as the way the statute is written, says one way or the other, how and when it should be done. Let me finish. You get a chance to talk, okay? Sure. So I would like for you to just give me a couple of...
Oh, wow. Now, Kathy is close to all that mess in Nashville, 15 miles from Hendersonville and Madison. I was shook up and slept in, very grateful, but, heartbroken for the deaths and destruction. Yeah, I'm glad that you're safe, and I'm glad that didn't hit you point on like that, man. I saw a lot of footage and pictures that were horrible. Looks like there's a lot of devastation in a lot of different areas throughout Tennessee. But yeah, Kathy, glad you're good.
Comments, please, in response to that. In other words, what is it in the statute itself that says that the prosecution, in statute or case law, however you want to find it, that says that the prosecution cannot, under the statute we mentioned here, 762... Point three, right, do exactly, what was done, here and now.
Criminal statutes, Your Honor, are strictly construed. In this case, 762.3, subparagraph 2, states in pertinent part, if it appears to the Attorney General that a felony has been committed within the state and it is impossible to determine within which county it occurred, the offense may be alleged in the indictment to have been committed and may be prosecuted and punished in such county as the Attorney General designates. The offense may be alleged in the indictment and be prosecuted in such county as the Attorney General designates. That presupposes that the Attorney General, before the indictment, and in every case ever reported under this statute, Your Honor, before the indictment, the Attorney General has designated the county, and then they have gone on. If they could do it the reverse, Your Honor, my point is that the reason the courts would have never allowed it is because this criminal jury instruction, the evidence must convince you beyond a reasonable doubt that the crime occurred on or about August 4th within the county of Wayne, would be rendered superfluous, because in any case where the prosecutor thinks that it is going to lose on this essential element of the case, all it does is send a letter up to the Attorney General like happened here, and it gets an order back, and venue is then removed from the jury. You do that in every case. Why would any prosecutor ever not do exactly what was done here if they could get away with it at the end of their proofs? Because they can't get away with it, because what you've done is if you could do this, and finally, Your Honor, if you could do this, there's no reason to have this criminal jury instruction. And finally, and most importantly perhaps, because the prosecution alleges that they really are seeking to amend the information, this court has to find that this wouldn't unfairly surprise or prejudice Dr. Kevorkian. Not only would it unfairly surprise and prejudice him, it removes the element from the offense, because the prosecutor at the close of his proofs indicates, I failed, Your Honor, I failed. The defendant should get a directed verdict because I have failed to prove an element of the offense because I don't know where it occurred. But I'm going to ask you, Your Honor, to forget about that because I got a buddy up in Lansing, and excuse my language, but I can go to the Attorney General anytime I want and get an order saying I don't have to do it. That cannot be the law of this state. And Your Honor, I can state to you without a shadow of a doubt that contrary to whatever the defendant claims the Court of Appeals said in a delayed application for leave to appeal, refusing to even hear a case, there has never been a reported case where the Court of Appeals or the Supreme Court has sustained such a legal maneuver, and also there has never been a case reported in which the amendment wasn't properly designated prior to the case coming to trial in the circuit court. That's just so obvious. If we didn't do that, there'd be no reason to have a jury instruction. Does that make it?
Yeah,
does
I
that
said
answer?
that's more to the point. Yeah,
Thank you.
Okay.
Trouble just walked in. Uh-oh. Glad you're here, Trouble. Welcome in.
Okay, go ahead and make your
I
final
think
remarks.
that's
Okay.
it, Your Honor. It
Okay.
violates the rules regarding the amendment. It violates the statute, and it can't be it's violative of constitutional rights.
Go ahead.
Your Honor, I would just call the court's attention to the fact that even if you strictly
I would just like to call the court's attention to the fact that I'm the prosecutor and do whatever the fuck I want.
construe the criminal statute 762.3, it does not impose any type of time restriction as to when this designation can and should take place. I think that the fact that there has been no case law specifically deciding the issue doesn't cut in favor of the defense necessarily. We know that there's an absence of appellate case law. That does not mean that it has been forbidden to allow this type of designation to be made once the trial has begun. It's possible because we can make these kinds of amendments on these kinds of venue issues, technical issues, that because they are relatively easy to correct, that can account possibly for the reason that there is an absence of case law regarding this. I would call.
Let's just get a somewhat of an ancillary point, and I can give you a chance to respond however you wish to other matters on this. But let's just assume, and I think we're well aware that there is law that allow for certain variances, to be corrected between the information, and the proofs and so forth. But isn't there also law that puts some limitations, on that based on whether that amendment or of that information becomes more than just something technical? And I suppose technical is relative. Surely you say it's technical, the defense say it isn't technical, and so where do you draw the line at in terms of what is or is not technical?
Well, I think if we look to some guidance, Judge, and that's why I threw out that statute 767.76, that talks about amendments of substance as well as what may be considered technical defects. In that statute, Your Honor, in the cases that have interpreted it, and for example, if the court looks at People v. Willett, which is a 1981 case found at 110 Michigan Appeals 337, they talk about prejudice occurs when the defendant does not admit guilt and is not given a chance to defend against the crime. Well, if you will recall, in this particular case, we had some protracted argument in terms of my motion in limine regarding one of the substantive defenses in this particular case, and it's not as if the defendant is left without any defense at all in this particular case. The defense that is going to be offered, that Mr. Feiger talked about in his opening statement, in addition to the one.
Oh, mullet alert. Look at that mullet on this one. Damn, son. Shit. Goodness gracious. Look at that thing. Got a nice little V in the front. Nicely kind of that's a little feather almost even. Look at the way it just kind of lays, right? If he could turn that right into bangs instantly. But he's got that feather back perfectly. Lays right on top of the back part, which is going into the party, right? He's still business, baby. He's still ready to own the world today. Could be president. You never know. You don't know what this man does. He could be representing Dr. K. I don't know. But you get back here, baby. Woo! Starts to flow a little bit. Got the curls in there, too. Look at that. Flowing down just a little bit down the side of the neck, right? Not long enough to get into the shoulders yet. But you can see where that thing can grow out to be a big, beautiful boy. Oh, Lord. Ha! Mullet watch, baby.
One about venue is the defense of the fact that Dr. Kevorkian was merely trying to relieve pain and suffering, and that is his defense. Your Honor.
Say no to globalism.
This is gun country.
What's up?
It seems to me that the court needs to consider the fact that this particular type of designation, if granted by the Attorney General, requires not just the prosecution making a claim or making a request, but the Attorney General must make a determination himself. And in this particular case, the Attorney General did make that type of designation, keeping in mind also, there has been I think clearly evidence that has been introduced indicating that the defendant was in Detroit. He was on Belle Isle. He was stopped on Belle Isle. So the notion of somehow selecting Detroit or selecting Wayne County as a venue for this particular offense certainly doesn't come as a total shock and as a total surprise to the defense. We would submit, Your Honor, that in the absence of the statute barring this type of designation being introduced, that we would request that the court permit it.
Okay.
There is could be no investigation by the Attorney General. They just wrote this letter, and the next day they got a typed order back. And if they thought they couldn't prove the offense, the statute says, go to the Attorney General and get this before trial. And then there couldn't be any prejudice to anybody. That's what the statute says. It doesn't say after you figure out that you forgot an essential element of your case, you can take it away from the defendant by simply, at the close of your proofs, going up there and removing an essential element of the prosecutor's case. If that isn't prejudice, I don't know what is.
All right, that's Mr. Kenny.
It certainly does not state in the statute that it must be done before trial. That's the defense interpretation and wish.
I have a copy of it. I'm aware of that. The primary concern here certainly is what the statute itself states and what might be.
Good morning, Pokemon. What's up? Shelly rolling through.
A reasonable interpretation of the statute, but moreover, there is also, I think, significant factors regarding what type and kind of amendment is allowed or should be allowed between the indictment, strike that, the information, and the proofs. I'm well aware that 763.6 the statute talks about allowing for some amendments between the two, but 763.6 talks about acquittal on variances. And that statute, and I quote, if any person who is indicted or informed against for any offense shall on this trial be acquitted upon the ground of a variancy between the indictment or information and the proof, or upon any insufficiency or irregularity in the form or substance of the indictment, he may be arraigned again on a new indictment for the same offense, notwithstanding such formal acquittal. And I'm assuming that since that's written as such, that if there's not an acquittal, they, it's a whole different, ball game. So I think that what I need, and I'm at a loss on right now, in spite of what the statute does and doesn't say about the time that it can be done, I think that the time factor becomes significant if it weighs heavily against some other possible rights and due process matters that may be involved or may be affected by allowing that amendment. I don't have the law at hand right now to respond to what that may be in the context of this particular case. Now,
Prosecutor's like, I am the law. Oh, sorry, excuse me.
If I'm asking, I suppose, at this point, if the proofs that are to be put in now certainly do not, or is not to be changed one way or the other, I think, by my decision on the legal aspects of this, is it okay to go ahead with those proofs, and then at some point, if it becomes necessary, to get those proofs in, and then I can maybe over the lunch break or something like that look at the law on this. Can we proceed that way?
Yes, Your Honor, because
Okay. Yes.
there's no further proofs that, in my understanding, would need to be put in. This doesn't go in front of the jury.
Exactly. And since we were talking about that, let me say this about that. I would ask, maybe require, and if necessary, order that this particular record be not discussed before the media by the parties. It's such I think, a significant critical issue in this case that I would like to be able to, as much as possible, have this decided as a matter of law and procedure rather than some other factors that may come out of that. So we'll ask that this record here not be discussed by the parties to the case.
Keep it in the circle, fellas.
And to the media prior to disposition of this case. So let's proceed with the proofs that you have, and I get a chance to look at this. I think it's a critical issue that we need to look at very closely. We can bring the body, I shouldn't say that. We can bring the jurors in, please, okay?
What the fuck? What is he about to say? You can bring the bodies in? Hold on. What the hell? I wish I could go back like 10 seconds. What the fuck are you talking about?
We can bring the body, I shouldn't say that. We can bring the jurors in, please, okay?
I've never heard it said like that. Yeah, let's go into the next one. You guys ever heard of that? You can bring the bodies in. He even corrected himself. I mean, the jurors, excuse me. All right, next video. Got another hour on us here. Sergeant Kenneth Day, now retired, Detroit homicide police sergeant. Kenneth Day takes the stand. Number 7. Thanks everyone again for being here. Appreciate the hell out of it. I'm going to hit you with a stinger. But yeah, what a good morning. Appreciate it. Always hanging and banging here on Murch Church. Is a little bit different than everything else we do here on Publicly Buzzed, as people probably can tell or know. We have a little bit of a variety of stuff that you're going to get with us. It's not all true crime, but a lot of true crime, for sure. I was hyping up. I'm getting really into the Bryce Rhodes trial that's getting ready to happen. I'm getting some more information on that in real time. And yeah, I've got a video dropping today on that. I spent yesterday putting some stuff together. I got intrigued on this. Holly Berry. Holly Berry's the person I saw post about this on Twitter. And she was talking about how, this guy could end up wearing something called a shock cuff because he's so belligerent and so crazy to the judge at all times. And I showed a little bit of this guy on Feral Friday. If anyone wants to go back and check that out, pretty much right at the beginning of the show with me and Jay. But this dude, what's so irritating and hard to watch with this motherfucker is he talks back to the judge. He blows kisses to the victim's family in the court, but talks back to the judge. And it's not like he's not one of the, like Jay said, he needs to drop his fucking nuts on the table. He's not one of these judges that's gonna, what did you say? What are you talking about? No, he's like, it's embarrassing. At one point, he's smiling, and the judge says, "I don't know why you're smiling, son." He's like, "'Cause I can." He's like, excuse me? Because I can? He's like, well, I mean, you can, but... And then this guy, Bryce Rose, just continues to go. He don't stop. He goes, continue what you were saying. Keep going. On with it. Keep going. And guess what? The judge just keeps going. They don't say anything. I've seen multiple judges also. I'm hoping this new lady judge that I've seen, I need to get her name, but she seems a little bit more badass. She's the one I saw the video saying, listen, this cuff could be used. It's up to you, basically, if it's used. So I'm intrigued. Another scene was him saying to a judge, are you and the prosecutor having sex? Are you guys are sexual partners? And the judge didn't say, this is out of line, this is outrageous. He said, well, no, we're not having sex. Buddy, that makes it sound like you're having fucking sex, dude. Sounds like you're fucking. What is happening here? This is Louisville, Kentucky. Again, I'm getting super intrigued. Alerts on, bells on. That's going to be dropping today, folks. You're not going to want to miss it. Let's go. Boom. And while I was ranting there, Cammy Q came through with 1999 passing the plate. Cammy Q, thank you for coming through here. First of all, let me hit you with a little bit of love. Love it. How dare also. Shit. Why not? Thank you so much, Cammy. Appreciate it. But yeah, we are getting ready to go into another vid. Let me catch up on the chat here just for a second. Hell yeah. All right. Thanks everyone for being here again. Appreciate it. Hit the like, share it out, all the good stuff. Let's keep rolling. Murch Church continues.
Full name, please.
Kenneth Day.
Sir, let me ask you, back in August of 1993, by whom were you employed?
Detroit Police Department Homicide Section.
You are currently retired from the department now, is that correct?
No. Back to the Bryce Rhodes, I'm assuming this was about. No. He won't talk to his defense attorneys. Won't speak to them. They went through multiple defense attorneys now. The current one is still with him, but you'll see in my video, the guy is basically like, he won't speak to me. We haven't spoke for years. It's insane. And the crimes are fucking horrible, okay? The crimes are this guy was this wannabe rapper. I've got some other stuff planned too that I might be dropping this week on this guy. A wannabe, rapper in Kentucky, gangbanger, but he wasn't just a normal gangbanger. He preyed on teens, on youth. That's who his crew was. So he's rolling around one day, and thinks, this guy's such an idiot. He thinks that he sees somebody that he's got beef with, guns this guy down with two of his gang members in the car. It's two teenagers. The guy that he kills isn't even who he thought it was. Okay. Cops start getting a little bit hot. He gets freaked out that these two teens are going to flip on him. They bring these teens back to his apartment, kill both of them. They're brothers. Also in that apartment was two other teens that are part of this gang. He made them also stab them to be implemented in the crime. It's a wild story, guys. Please check my video out today, dropping. It shouldn't be long after this ends. I've only got to do a couple of things. I want to put a couple of more just bells and whistles on it, but I did a lot of work yesterday. It's pretty much ready to rock and roll, and I'm super intrigued by it, though. I really am.
That's correct.
At the time of August the 4th and August the 5th of last year, what was your rank with the department?
Sergeant.
Let me direct your attention, sir, to the date of Thursday, August the 5th. On that occasion, did you have an occasion to go to a location in Southfield, Michigan?
Yes, I did.
And do you recall where in Southfield you went that day?
No, I don't recall the address, but it was to the office of Attorney Feiger.
Okay. The gentleman seated to my left?
Yes.
Okay. And do you recall what portion of the day it was that you went there?
It was in the afternoon.
What was your purpose in going to that particular location at that time?
My purpose was to see and hear an interview given by Dr. Kevorkian to the news media.
And did, in fact, a press conference take place?
Yes, it did.
Can you tell us, please, were you present for that particular press conference?
Yes, I was.
And Dr. Kevorkian spoke at that press conference?
Yes.
There has been a videotape that you have seen before today's date, is that correct?
Yes.
And the videotape that you saw, is that an accurate rendition of what you saw take place at that press conference?
Yes, it is.
Okay. And People's proposed exhibit number 8. Is that in fact the videotape that you have seen before?
It appears to be so.
Your Honor, I'd move forward to this point.
Mr. Feig, all the matters that are already on record, no objection? Okay.
Other than the matters already.
All right, proceed then, please.
If I may just have a moment, Your Honor.
Okay.
Watch your ears.
Just, it appears that the tape supplied to me was, if this is the same tape supplied to me, I'd just like for the record, it appears to be from WXYZ TV.
Is that?
That's fine.
Okay.
All right, go ahead.
Excuse me, the TV is farting. This is like actually how you edit like like something now. If you wanted to have that retro vibe, is with all of those extra little beep, burp, beep, burp.
Could I have everybody's attention?
I think he said XYZ, if I'm not mistaken, Cammy.
Please, Dr. Kevorkian will be making a statement. He'll take no questions. I don't care. Just please understand, okay. He's not going to answer any questions. He's going to make a statement right now. Go ahead, Doctor.
Well, thank you all for coming.
Go ahead.
Thank you all for coming. I know it was short notice. First of all, I want to express my gratitude to the police officials and their colleagues in Wayne County. I've been twice now. I've been treated very cordially by them. I don't have a single complaint. It was very nice the way they handled everything. Lieutenant Stewart and Oslin and their co-workers, I want to give them special thanks and expression of gratitude. Also, I really, no matter what his personal feelings on this matter or about me, I must say I have the highest respect for the professional integrity of Prosecutor O'Hare. It's been, for me, quite an experience. Without any kind of difficulty or inconvenience at all, I've been treated well up and down the line, and I want to give him my best wishes too for that reason. I stated emphatically that I helped Thomas Hyde in his suicide, merciful suicide. I thought that would be enough yesterday. That's why this session was called. And I understand now that Prosecutor O'Hare needs more material. I really have sympathy for Prosecutor O'Hare. I understand the rather untenable position he's in. The old trite phrase, between a rock and a hard place. And I want to do everything possible to make his job easier, because that's all he's doing is his job. And I think he's doing it well. He has to do what I call dirty work of the legislators and our leaders of the people in Lansing. And by people, I mean collectively, the governor, the legislators, and the medical politicians. It's their conspiratorial attitude that has put Prosecutor O'Hare in this bad position, and I want to make it easier for Prosecutor O'Hare. Therefore, I was contacted by Thomas Hyde almost 2 months ago, I think, maybe a little more, and had personal sessions with him and some telephone contact with his wife Heidi. I could not talk with Thomas Hyde on the phone because he couldn't speak. It was unintelligible. Heidi would have to translate everything for me on the phone. In fact, in our personal discussions, I could not understand what he said. Heidi had to translate it, so to speak, for me. He could just make sounds and grunts that, to me, I couldn't make sense of. I made sure that his decision was irrevocable and was solid. I made sure there was no wavering whatsoever, and there never was. Every time I brought the idea up, the question as to was he aware of what he was going to do, he always reacted with a sense of relief. And so I decided to proceed when things were deteriorating rapidly. And I had learned myself from the press today that he was soon to be put in on tube feeding, which he didn't want. I supplied the van, which was my personal van, and at no time was there anybody else in the van but me and Mr. Hyde. I drove him to Belle Isle. I supplied the gas. I supplied the tubing and the masks and all necessary equipment. I connected the tubing to the tank. I put the clip on the tubing. I put the mask over on Mr. Hyde's face because he could not move that much. He could barely move his left hand, his left forearm, and he could not even extend his fingers. His fingers were almost fixed they were in fixed position. He could not move them very much at all. As I said, I put the clip on the tubing to obstruct flow. I turned on the gas on the main valve on the tank. And of course, nothing happened because of the clip on the tube. I asked him one more time if he was sure of what he was doing. Again, I couldn't get an intelligible reply, but there was a small smile you could see crack his lips, and he looked up with sort of a pleasant face, pleasant eyes, and a moan or two, which I thought I heard he saying, "I'm fine." That's the best I could make of it. And then I decided to go ahead. I instructed him then if he was sure, then all he had to do was move his left forearm a bit and pull. There was a short string of about 6 or 8 inches to the clip tied around his finger, and he then pulled the string, and the clip came off the tubing, and it was a slow flow of gas, very, very slow volume. And he then went on and died. And I want to say now that that I hope this issue now can be raised to a level for the sake of for those who are suffering. Thank you.
Dr. Kevorkian will have no more to say regarding this. I'll be glad to answer any questions. He will not say anything, please, okay?
It sounds like you specifically want...
Guarantee they were asking him questions. Yeah, dude. Dr. Kevorkian's awesome, man. Back shot of the mullet there.
Sir, you participated in the investigation into the death of Thomas Hyde, is that correct?
That's correct.
Now, you are familiar with Belle Isle, is that correct, sir?
Yes.
And Belle Isle is located in the city of Detroit?
Yes, it is.
County of Wayne?
Yes.
Now, do you recall, sir, whether or not during the course of the investigation any efforts were made to try to get any
Yeah, even with all of this fighting and work in the state of Michigan that Jack Kevorkian did, you still don't have access to assisted suicide if you're ailing so much that you can't even function and you have to end up going into hospice or something. It's horrible. I just looked up the states you can do it in: Maine, New Jersey, Vermont, New Mexico, Montana, Colorado, Oregon, Washington, California, Hawaii, and then Washington, D.C. you can as well. I think Colorado was the first. But at this point in time, when Dr. Kevorkian was fighting and bringing this to the forefront of with people and in the media, I don't think any state was doing it. I think Colorado was the first. And Michigan is still, honestly, probably the higher-ups, the actual elite in that state, are probably just fighting it out of spite. There's probably still some old heads that remember these days that didn't want to, didn't like what was going on here, because the state doesn't want this to be, it should be a human fucking right, man. It should come right back down, especially in these circumstances. We went into it deeply on here, especially during this one. But it should be an absolute human right. If you're ailing that much and you're on your way out, and who knows how long you have left, you can't function, your day-to-day is gone. Yeah, man, it's horrible. And then your option is, well, now you're in hospice and we can make you as comfortable as we possibly can until the end. No, dude. The states that are doing it, awesome, though. Closest one to here would be New Jersey. But, man, all these states need to... I need to look into see if this is something that's talked about regularly, in different states. I want to know where it's at in Michigan. You think Michigan would have been yeah, okay.
Payphone, public payphone records?
I believe there were, but I don't specifically recall.
Okay. Now, there was reference on the tape to the fact that Dr. Kevorkian had an earlier meeting or contact. Had you ever seen or met Dr. Kevorkian before?
Yes.
And when I say before, I'm referring to before August the 5th, 1993.
Yes.
At the time that you saw Dr. Kevorkian before August 5th, 1993, where was that?
That was at Detroit Police Headquarters at the homicide section.
And could you tell the jury, please, where is Detroit Police Headquarters located?
That is located at 1300 Beaubien, which is about across the street from this building.
Okay. Can you tell us, sir, with regards to this particular investigation, were you aware of Dr. Kevorkian's residence in Royal Oak?
Yes.
Can you tell us, please, had you been to that particular location?
Yes.
Can you tell us, please, from where his residence was in Royal Oak, and are you familiar with where the Harbor Master Station is on Belle Isle?
Yes, I am.
Can you tell us, sir, are there any other Detroit police stations or units that are closer to Dr. Kevorkian's Royal Oak residence than the Belle Isle Harbor Master's office?
There's several, yes, there are.
And what units might that be, or what stations?
That would be the 12th Precinct, which is on 7 Mile and Woodward. There would be the 11th Precinct, which at that time was on Davison near the Chrysler. There would be the 13th Precinct, which would be Woodward and Hancock. There would be the 7th Precinct, which would be Gratiot and Mack. And, of course, there would be police headquarters.
Okay. And with regards to this particular investigation, the investigation of Thomas Hyde's death was conducted by the Detroit Police Homicide Section. Is that correct?
That's correct.
Would the Detroit Police Harbor Master unit investigate something that would be classified as an assisted suicide?
No.
Can you give us some rough idea, sir, as to where Dr. Kevorkian's Royal Oak residence was?
It's on South Main. That would be Woodward, 11 Mile, and South Main, that area, which would basically be 10.5 mile Woodward area.
Are you familiar with where the Royal Oak Police Department is located?
Yes, I am.
And where is that located in relation to where Dr. Kevorkian was living, if you know?
The streets, I can't tell you, but it may be 3 blocks away.
Okay. Now, when you were a sergeant with the Detroit Police Homicide Section, did you investigate or go to crime scenes?
Yes.
And part of your responsibility is to direct evidence technicians or examine crime scenes as well, is that correct?
That's correct.
In this, if a particular assisted suicide were to have taken place in a van, in a vehicle of some sort, what would you consider the crime scene for purposes of your investigation?
Of the van.
Okay. Your Honor, I believe at this time I have nothing further to witness.
Mr.
Just a
Feiger.
couple of questions, Mr. Day. How long were you with the Police Department Homicide Section?
13 years.
You must have investigated hundreds of suicides during that time, correct?
Quite a few, yes.
Other than the search warrants that you executed on Dr. Kevorkian, did you ever execute any other search warrants relating to a person who had died as a result of a suicide?
Not that I recall.
Thank you. I have no further questions.
Mr. Kenny,
Nothing further, Your Honor.
Sergeant Day, thank you. Enjoy your return.
Thank you.
Okay. Go ahead, Mr. Kenny, anything?
Could we approach, please?
Sure. No, Drew, there are some matters I need to take up with the lawyers out of your presence. I'm going to just have you take your noon break, lunch break now, and have you report back to your jury room at 1:45. 1:45, 1:45 for you to be back in your jury room. Okay? Yes, sir. I'm sorry.
I'm sorry. I thought Mr. Kenny was simply going to place a couple statements on the record and then have the jury retire now.
I thought we were going to do that. You had some witnesses you want to weigh. You want to do that now?
I can do that now.
Okay, go ahead. I'm sorry. You can do that now then. Okay.
Your Honor, it's my understanding that for purposes of this trial, the people in the defense are willing to stipulate and waive the testimony of the following witnesses: Lieutenant William Presley from the Detroit Homicide Section, who would testify regarding driving the van from the Harbor Master Section to the Wayne County Morgue. And also waive the production of Dr. Joseph Montfort, who is a toxicologist from the Wayne County Medical Examiner's Office, who supplied toxicology and chemical reports to Dr. Casson for the basis of his testimony in court here today.
That's correct, Your Honor.
Okay, thank you. And that simply means that there are people who are often listed on the list as prospective witnesses, and quite often as the trial develops, it becomes unnecessary to actually call those persons in to testify, so both sides are agreeing that those two persons would not be needed to testify here in court. Okay, now, as I said to you before, you are not to discuss this case with anyone among yourselves, and avoid any and all contact the person involved with the case. Be in the jury room at 1:45.
Mr. Kenny,
Yeah.
can I say one more thing?
I'm sorry, was that something else? I keep maybe missing out on things.
He's trying to get the hell
Was
out
it
of
else?
here. He's like, can we go?
Well, actually, there are a couple of things, Your Honor. One of them being the matter regarding People's Proposed Exhibit Number 3, which had been the subject
I
of...
withdrew my objection, and now you're going to go.
Okay, so the exhibit 403 there that we had was the photograph that was being discussed by the evidence tech, Mr. Lane. That exhibit will be admitted into evidence. That was the one where he's talking about the photograph of the hand and so forth. That's admitted into evidence.
Your Honor, at this time, I would like to publish the photos to the jury, and with that, the people rest.
Okay, go ahead. Go ahead and do that then. Let them look at those. As soon as we get that out of the way, we'll break for lunch then. Okay. I think they're seeing 2 or 3 of those already, haven't they?
Yes.
Okay. Keep in mind, members of the jury, that any and all the exhibits that are formally admitted into evidence by the court, you have the right to see those during your deliberation process. So don't feel that this is the only time that you have a chance to look at those. If you wish them in the deliberation process, you will be able to see them. One other matter, the prosecution indicated that it was resting its case in chief. That's being withdrawn now, and there's no formal resting on the record just yet. Okay? All right. Okay, we finished looking at the photographs. As I said, again, be back in the jury room about 1:45. Okay.
Court is back in session.
Okay, please be seated. Thank you. Okay, before I should say the first order of business is the matters that were raised earlier. I assume that this is the opportune time to try to decide the issue regarding the question of venue. Mr. Kenny, you did not formally rest your case yet. I think we made that clear on the record. I'll take any other brief statements from either side. First the prosecution, then defense, then prosecution, if there's anything else that wished to be said about the issue we discussed earlier.
Lunch motivated. That's a shirt. I'm going to write that down. I don't know what I'm going to do with it. I'm going to make some kind of design with that. Lunch motivated. I like it.
Your Honor, just a couple of brief comments, if I may. I think when one examines the statute 762.3, which permits this designation of a venue by the Attorney General, the fact that the Attorney General can, on his own, make this type of designation, I think, is an indication that the issue of venue is not viewed as critically as the elements of the offense. It is not as if the Attorney General, on his own, can in fact abolish or do away with the prosecution's requirement to prove certain elements like knowledge or items like that. The other thing I would call to the court's attention is the designation that we have requested is not really changing the venue, if you will. It is, in effect, designating what has, in fact, been initially alleged in this particular case. Thank you.
Okay. Mr. Feiger.
I have two motions. Well, The prosecutor, I understand, Your Honor, has made a motion to amend the information at the close of his proofs. And that motion, as I stated earlier, is based upon a letter written last Thursday to the Attorney General saying it is impossible to determine with absolute certainty within which county, district, or political subdivision the offense occurred. And then the Attorney General immediately gave him back an order saying, it appears to me that the exact location of the commission of said offense in this matter cannot be determined, even though an extensive investigation has been conducted. Well, I think that's patently false on its very face, since no investigation was conducted at all by either the Wayne County Prosecutor's Office or the Attorney General's Office. And to just submit matters to the court with the requirement that an investigation take place when none, in fact, has ever occurred is an outrage. And I bet if we called the Attorney General to the stand and asked him what investigators he had investigate this matter and under what circumstances he investigated this matter, we will determine that absolutely no investigation was done, because we know none was done by the prosecutor's office, because we've heard all the evidence. And now now for the Attorney General to write that even though an extensive investigation has been conducted when we know that's not true, and the Attorney General didn't do one and the prosecutor didn't do one, is just a fraud upon this court. Even if the court was to assume this, I don't think the statute obviates I don't think they can amend the information at the close of proofs to put in an essential element of the case, which is that proof of venue is an essential element of the prosecution's case, which must be proved beyond a reasonable doubt. And they can, at the end of their proofs, seek to have this court amend the information because of the overt prejudice it would cause the defendant in this case. Moreover, I'm not sure what the prosecutor's position is. I thought he was saying that now that he's made this arrangement with the Attorney General, he doesn't have to prove venue anymore. And I don't even read the statute like that. The statute says the responsibility and the authority with reference to all steps in the prosecution of such case shall be the same. So I believe that even if the court would to allow this, it's simply evidence that the prosecutor tried to secure a order from the Attorney General, but it doesn't decide the matter or take it out of the jury's hands if it did.
I would agree with you with that, because I think that essentially what it does is, well, let me rephrase that.
Sure.
It still is an issue. Venue is still an issue, I think, for the jury to decide, and it's a question that would be presented to the jury, to prove the venue wherever that venue allegedly is, according to what they allege, in the information, or if I, allow the modification of that. I certainly don't think Mr. Kinney.
Tonight at 7:30 press conference. And actually, I just set that up. I did see that. I just set the portal will take you into that actually. Where we announce what we're doing with both channels. And if anybody missed it, I think it was Friday, Jay got the original Shaming of Jay channel back to remonetization. He had to delete literally everything he's ever done. But yeah, he's back, baby. And so we're going to figure out tonight, or going to find out tonight, what is happening with both channels. So hell yeah, excited to see that. Make sure you're hanging out. I guess that's going to be on the JBN channel, Jay?
Argued, or that he intended to argue, that the venue is foreclosed. The question is foreclosed to the trial fact based on that.
Thank you.
Situation.
Then assuming that, I would simply say that this is simply untimely to amend in this fashion. And then I would make a motion for directed verdict on the basis of the standards set forth in People versus Hampton, which is simply as follows.
Okay, you're doing it live on both? Okay, nice.
With regard to the test to be applied by this court in such a motion, the Supreme Court said in People versus Hampton 407, 354 at 368, in quantitative terms, the fact that a piece of evidence has some tendency to make the existence of a fact more probable or less probable does not necessarily mean that the evidence would justify a reasonable juror in reasonably concluding the existence of that fact beyond a reasonable doubt. Due process requires that the prosecutor introduce sufficient evidence which could justify a trier of fact in reasonably concluding that the defendant is guilty beyond a reasonable doubt before a defendant can be convicted of a criminal offense. If sufficient evidence is not introduced, a directed verdict or judgment of acquittal should be entered. And I think that, with all due respect to the prosecutor's case, I think the prosecution has presented zero evidence to show that Dr. Kevorkian or anyone committed any crime in Wayne County. The prosecutor asked the jury to assume that since Dr. Kevorkian was on Belle Isle with Thomas Hyde's body, that Thomas Hyde committed suicide on Belle Isle. I acknowledge that he has presented evidence from Dr. Casson, who has indicated that Thomas Hyde could have been dead for 1 or as long as 4 or 5 hours. That would put the time of his death, assuming Dr. Casson saw him at 11 a.m., sometime between 6 a.m. and 11 a.m. But that doesn't establish anything which would allow the jurors to find beyond a reasonable doubt that this crime, alleged crime, occurred in Wayne County. He has produced evidence from a deputy who indicated that she saw Dr. Kevorkian's van and did not see Dr. Kevorkian at some time between 8:10 and 8:30. That simply does not establish anything beyond a reasonable doubt, since Dr. Casson has already indicated that Thomas Hyde may have died sometime between 6 a.m. and 10 a.m. on the morning of the August the 4th. The prosecutor has produced no other evidence which would even suggest it, and there is no presumption of this vital element of the case. On what basis, rather than simply inferential, and it's really more than inferential, the prosecutor, Your Honor, is asking the jury to presume an essential element of the case. I think that under the rules of criminal procedure, there has to be some basis upon which this court could conclude that a reasonable trier of fact could conclude beyond a reasonable doubt that it occurred. And under the set of circumstances in this case, the jury would be making up facts to conclude beyond a reasonable doubt that it occurred in this case. And for that reason, Your Honor, I think a motion for directed verdict is appropriate at this time. But in any respect, and I think the court has indicated that the court does agree with me, that this is at a minimum a question of fact for the jury, because I intend to include it, as I stated in my opening argument, that issue to the jury.
All right. Thank you, Mr. Feiger. Mr. Kenny, you may...
Can I say just one more
Sure,
thing?
go ahead.
In the case that Mr. Kenny asked the court to consider, I might add that the prosecutor sought the order of the Attorney General and obtained same before trial started, which is significantly different than this case. I think Mr. Kenny admitted same, but I wanted to put it in my argument. I would again assert that there has never in the history of the state, even in a circuit court, been a situation where a prosecutor has been permitted, under the circumstances that exist here, to make an amendment according to the requests that the prosecutor has set forth. Even this case doesn't stand for that position. That would be the state of Michigan versus Victor King Malone.
All right. Thank you. Mr. Kenny, you may respond on that general issue to what Mr. Feiger said, and also you may make your response to his motion for a directed verdict.
Your Honor, am I correct with regards to the argument regarding the directed verdict motion that I heard Mr. Feiger mention? It was directed toward the issue of not establishing venue?
That's how I understood it, basically, yes.
Okay.
I didn't hear it on anything else.
All right. Your Honor, with the Malone case, it is certainly true that the petition and order was sought before the trial. An examination of the trial transcript, which I have and have made available for Mr. Feiger to examine, clearly indicates that the prosecutor made an opening statement and talked about the crime occurring in Southfield, and it wasn't until the middle of the prosecution's proofs that the designation was introduced. So it was not done right from the beginning of the trial. And with regards to the comment that this has never occurred, even at the circuit court level, I've talked to Mr. Ianni at the Attorney General's office, and he told me that that's simply not the case, that it has been done in other cases, in other circuit court jurisdictions throughout the state, where during the middle of the trial, the designation has been applied for and has been granted. If I may now turn to the issue of the request for a directed verdict under the Hampton standard, and certainly the court is well aware of the fact that the court may consider circumstantial evidence as well as direct evidence. And regarding the issue of venue, whether or not sufficient evidence, when considered in the light most favorable to the people, has been presented such that a trier of fact could in fact find guilt beyond a reasonable doubt, I think we have to take a look at the fact that based on the testimony of Officer Banks and Officer Green and Inspector Arthurs, there is certainly reason for a fact finder to conclude that the defendant, Dr. Kevorkian, may have been on Belle Isle from as early as 8 o'clock in the morning till as late as sometime shortly after 9:40 in the morning when the vehicle was stopped and pulled over. That puts the vehicle on Belle Isle for a period of 1 hour and 40 minutes. We can then look alongside that particular evidence and see Dr. Casson has said that the time of death occurred anywhere between 1 and 5 hours from the time the body was brought to him in the morgue, which was around 11:30 in the morning. That would certainly make it consistent. A rational finder of fact could conclude by looking at the testimony of Dr. Casson and his estimation regarding time of death, and the officer's testimony when pieced together showing how long Dr. Kevorkian was on Belle Isle, one could certainly draw the conclusion that Thomas Hyde's assisted suicide took place while he was on Belle Isle. But thirdly, Your Honor, I think we need to take a look at the tape, which has been marked, I believe, as People's Exhibit number 8. And when we look at the tape in its totality, I think it is clear that a rational finder of fact could conclude from not only the words that were said, but the order in which the events were laid out by the defendant, together with the atmosphere that he was trying to create, that it is clear that the assisted suicide took place on Belle Isle. It's important, I think, to note that in the tape, Dr. Kevorkian indicates how he respects Prosecutor John O'Hare and how he recognizes that Prosecutor O'Hare needed more information in order to bring these charges. Clearly, the impression that's created during the course of that August 5th tape is that Dr. Kevorkian is trying to meet the issue of the assisted suicide statute head on to deal with the merits. And I think when you hear that Dr. Kevorkian says on the tape at the press conference that he is trying to make things easier for John O'Hare, that is something that a rational trier of fact would take into account when Dr. Kevorkian then launches into an explanation about how he used his personal van and at no time was there anybody else in the van but me and Mr. Hyde. And then he says, I drove him to Belle Isle. And then after that, he talks about how he supplied the gas and he supplied the tubing and the mask. And he talks about putting on the clip and how he then put the mask over Mr. Hyde's face because he couldn't move that much. And then he talks about turning on the gas flow. And then he talks about double checking with Mr. Hyde to make sure that that's what he really wanted to do. All of this moves in a very logical and progressive sequence. And I would respectfully submit to the court that when you look at all of those items together, a rational finder of fact certainly could conclude that the assisted suicide of Thomas Hyde did in fact occur on August the 4th, 1993 on Belle Isle. Thank you.
Okay, Mr. Feiger.
Very good. Dr. Kevorkian didn't say. Everybody knows he drove to Belle Isle with Thomas Hyde. I mean, he didn't need to say that on a tape. That's where he was. That's where he was driving into the police station. I mean, by the virtue of the fact, ipso facto, that he was on Belle Isle with Thomas Hyde, the prosecutor says the jury should conclude the crime occurred there.
That's not what I heard. Let me just interrupt you briefly as you continue. What I'm hearing here was a remark prior to that the sequence of the order in which he mentions, that is indicative of it being on Belle Isle. In other words, drove, then did this, and then did the other thing. That's how I look at it.
That's what I heard, that the prosecutor's asking that because, and I agree with Your Honor, that because the way Dr. Kevorkian related it in this press conference in terms of sequencing, that proves that it happened on Belle Isle, and that he did one thing first, which he didn't say, and then did all the other things afterwards, which he didn't say. And that's the prosecutor's sole position, that if you describe events which occurred and you put them in an order, which you have to do since we're living in a compendium, therefore it proves that one thing happened after another. That's just not true, but that's the basis, and that's what I hear the prosecutor to be arguing, and that doesn't provide a basis for the jury to conclude it occurred on Belle Isle. I can represent to the court, it didn't occur on Belle Isle, but I guess there's a difference of an opinion on that.
Okay. Let me sort of organize my thoughts here and sort of take these things in sequence, because I have essentially two motions that are before the court. One has to do with the prosecution's requests regarding the designation of the venue by way of the request that was made to the Attorney General. The other has to do with the defense request for a motion for a directed verdict, though both are centered on the same issue, the general issue of venue. Let me begin by expressing something here now that I expressed to the attorneys at the very beginning of this case last week, and that is I had anticipated that this would be a trial that would give the trier of fact the opportunity to hear and air out the issues that are involved with this, and that with that in mind, my discretionary decisions would probably be somewhat broad and liberal and enable to both sides to get to the heart of the issues that could legally be presented within the rules and guidelines that are allowed by statute. Now, that is not meant to be a statement in terms of how I rule on issues or what is the governing principle there, but certainly to hopefully put in focus and perspective at least my own concerns about the case getting to the trier of fact, and letting the trier of fact be able to make decisions on those issues. That may have been, I shouldn't say may have been, but was part of my reasoning and admitting certain evidence last week that was opposed by one or the other side, particularly the tape that I was looked at last week. Now, beyond that, however, certainly I think we all agree presently that on the application regarding the designation by the Attorney General, there is a statute that allows that procedure. We're talking about the Michigan Compiled Law 763.6, which has the general title I'm strike that, not 763.6. I'm looking at the one on variant 762.3, talking about the venue factor. And just to put that wording of most of that, or the gist of that on the record here, subparagraph 2 of that says that if it appears to the Attorney General that a felony has been committed within the state, that it is impossible to determine within which county it occurred, the offense may be alleged in the indictment to have been committed and may be prosecuted and punished in such county as the Attorney General designates. The state should bear all expenses of such prosecution. The responsibility and the authority with reference to all steps in the prosecution of such case should be the same as between the prosecuting attorney of the county so designated and the Attorney General, as though it were an established fact that the alleged criminal acts, if committed at all, were committed within that county. Now, certainly the plain reading of that particular statute does not state any factor regarding time and when such designation should be made. Thus, what we have here by way of case law and/or cases on that is it running the gamut apparently from a considerable period amount of time before the trial and based on the case that was mentioned today that was offered for guidance out of Oakland County, that even in the midst of a trial, the fact of the existence of the statute and allowance for its use is also found in the case of People v. Brasic, B-R-A-S-I-C, at 171 Michigan Appeal 222, a 1988 decision that was mentioned in the commentary to the statute and suggested as one of the more recent cases, I guess, that has looked at that. But even in that case, the request for the designation and the order itself was entered prior to the trial itself. And as indicated, other than the case that's presently here, although apparently there's some information from person who deal with these often that this happens fairly often. But again, in my looking at it, I'm guided by the precedent of case law and also some degree of statutory interpretation. And again, the statute itself, I believe, does not say when that can be done. With that in mind, then that the statute is silent and not by implication, I also find give much guidance as to when the requests must be made. I think then it becomes a question of a general application of the law in terms of variances between the information and the evidence as to when and how such variance should be allowed. Now, the statute, in fact, that the court rule, MCR 6.112, has to do with the information or indictment and give certain guidelines as to his use, his time of filing, the nature and content of same, and so forth. And subparagraph G of that specifically states, and I quote, the court before, during, or after trial may permit the prosecutor to amend the information unless the proposed amendment would unfairly surprise or prejudice the defendant. On motion, the court must strike necessary allegations from the information. And it also, as part of the staff comment or use note that often accompanies such statutes, there is the statement that sub-rule G implements existing law. And it also says, and I quote from that, what type of amendment may or may not unfairly surprise or prejudice the defendant is left to case law. It's kind of circular reasoning there. The statute or the amendment is to be governed by case law, and then I find that there's little case law to give much guidance on that, except in some cases that are not directly on point, but do offer some statements about that. One of those that were mentioned and I looked at is People v. Strickland, Stricklin, Strickland on page 633. And by the way, I recognize that Strickland had to do with a criminal sexual conduct matter involving a young child, so certainly the facts are not in any way governing, but I'm looking at the legal principles there. But this was a situation where the information was allowed to be amended. And the court said at page 633, and I quote, "A trial court may amend the information at any time before, during, and after trial in order to cure a variancy between the information and the proofs, as long as the accused is not prejudiced by the amendment and the amendment does not charge a new crime." Reference is made to MCL 767.76, also to the case of People v. White, found at 22 Mich Appeal, page 65, a 1970 decision. Further, I'm quoting from Strickland at page 633, "Prejudice occurs when the defendant does not admit guilt and is not given a chance to defend against the crime." And there was another part of the Strickland case on page 634 that had to do with the time of the offense. And there, reference is made, and I quote, MCL 767.45, subparagraph 2, with the parallel MSA citation being MSA 28.985, subparagraph 2. Provides that information shall contain the time of the offense as near as may be, but no variancy as to time should be fatal unless time is of the essence of the offense. Again, I realize that the issue is not time here, but again, hopefully using that as some guidance on what the courts have said in general at looking at this. And of course, that brings to mind certainly the concern that if the issue of prejudice and unfair surprise and such other factors are to be controlling, certainly they have to be viewed in the context of the matter that is at issue in this particular case. Now, I realize that the defense has in its opening statement made the statement that this particular offense did not occur in Detroit or in Wayne County. And although that's information in the case, that is not proof, because
I can picture this. Rango! Rango! I can picture this. Oh my God. Rango! Rango! I don't understand. It's not working. Rango! Wango!
This is often told a trial fact. What the attorneys say at the time is not evidence in the case, but it certainly raises the issue now as to proper venue. Now, I think that in answering that concern, based on the case law statement, the controlling question, I think in this case, then become whether or not the defendant would be deprived of a fundamental right that would amount to almost a manifest injustice or some failure or justice would result with the allowance of the amendment that is proffered by the prosecution. And then that part of that concern in question is whether or not place is essential in making that the overall decision, or is place a material element of the charge here. Now, I do not, and I wish to emphatically state that it is not for the judge to decide and take away from the trier of fact, the jury, the question of whether or not venue has been shown or can be shown by the facts that the jury is allowed to consider. And I don't mean in any way for this record to deem my statements or what's been said here forecloses that to the trier of fact. And I think that when we sift through this, both sides basically agree to that. But certainly the issue here is what is the prosecution allowed to present to the trier of fact as the venue of the particular offense. And I dare say that as an aside to this, that in presenting that particular question to the trier of fact, that they are not. In fact, I would not even essentially tell them my reasoning and making any decision on that, but certainly they would have to be notified of any change that would be made. Now, again, looking at this in terms of whether or not the amendment would result in unfair prejudice, or I think that the wording is used as unfairly surprised or prejudice. The defense is the wording that is used. I'm not sure what does it mean to say that an amendment might unfairly surprise. That is, in my mind, a somewhat amorphous concept, because I would think that any kind of amendment could be an unfair surprise based on the circumstances of any particular case, and that is difficult to measure that by basis of unfair surprise. Certainly, when we talk about prejudice to the defendant in a criminal case, we look at the ability to present a defense, or whether or not the amendment itself would prevent that particular offense, or that amendment would amount to a manifest injustice that would affect or deprive the defendant of a fundamental right. And again, I think that the wording that I read here from the Strickland case here, prejudice occurs when the defendant does not admit guilt and not given a chance to defend against the crime. I feel that the factor of the venue on this and allowing an amendment to it would not cause the prejudice or the manifest injustice or the other factor of affecting a fundamental right by my allowing the prosecution to make that particular amendment. Now, I say outright that certainly there is a lot to be done and said about the nature of this particular statute there, and although it has been used and perhaps will continue to be used, it has a purpose, an objective in mind to cure a circumstance that may occur where there may be such confusion, and certainly there are cases where that occur. I do somewhat agree that there's a certain inherent danger that's there where a particular defense may have as its primary reliance the proof of the place, and whether or not the proof of place or venue becomes significant, again, is weighted in terms of the facts of any particular case. And there may very well be need for further guidance from either a higher court or something else that need to be said in order to perhaps refine what the possibilities may be, because certainly that to be able to, I think, get a designation at any point in time can, in certain cases, I think, severely and perhaps fatally affect a prosecution where those facts may fit that. But it's my conclusion, at least on the facts of this particular case and the circumstances that are here, that the venue is not such a significant issue, or that my allowing, I shouldn't say that, let me rephrase that, venue is an issue, but that allowing the amendment as to the venue does not affect that in such a way that I think that the defendant is being denied the fundamental right to a defense and being able to present the matters to the trier of fact. Certainly, if this is an issue, the whole issue of this case is one to be decided at some point by a trier of fact. And although I parenthetically do not fathom the significance of a trier of fact making a decision in this case in any way, because it certainly does not resolve the overall issue of where this statute is and what its future may be. But in terms of the jury being able to consider that question here, I don't think that it is to be weighted only in terms of whether or not the matter occurred in Wayne County or Oakland County, but to let them, the prosecution, be able to amend it and then let the trier of fact make that decision. Now, on to the other aspect of this, and that is the motion that made by the defense for a motion for a directed verdict, which is a motion on the issue of whether or not there is sufficient evidence for the matter.
This deep legal analysis that's going on is
to go to the trier of fact. As indicated in the argument here by defense counsel, the seminal case that applies to standard for a directed verdict is that of People v. Hampton, found at 407 Mich. 354, a 1979 Michigan Supreme Court decision that basically adopts the principles found in the U.S. Supreme Court case of Jackson v. Virginia, found at 443 U.S. 307. Essentially, Hampton says that in order to obtain a valid conviction, a prosecutor must present the fact finder with evidence sufficient to prove guilt. And that sufficiency inquiry does not require the court to ask itself whether it believes that the evidence establishes guilt beyond a reasonable doubt. At this juncture, the relevant question is whether a rational trier of fact could find the essential elements of the crime beyond a reasonable doubt. Hampton and cases that follow Hampton also recognize that the trial judge, when ruling on a motion for a directed verdict, must consider the evidence presented by the prosecution up to the time that motion is made, view that in a light most favorable to the prosecution, and determine whether a trial of fact could find the essential elements of the crime beyond a reasonable doubt. Essentially, I think the rationale of Hampton is that the sufficiency of the evidence inquiry requires that the prosecutor introduce sufficient evidence on all the elements. And that concept or sufficiency is designed to determine whether all the evidence considered as a whole justifies submitting the case to the trier of fact or requires a judgment as a matter of law. The Hampton-Jackson v. Virginia principles certainly are based on due process requirement that the prosecutor introduce sufficient evidence which could justify a trier of fact and reasonably concluding that the defendant is guilty beyond a reasonable doubt before the defendant.
All right, hold on. I've got to share this with you guys real quick. I can't play the music, unfortunately, because it's Sweet Dreams Are Made of These, and I'll get the copyright, but holy crap, this lady is getting down. Oh my God. I love videos like this. I'll give you just a second of the tunes just so you can get the image in your head. What in the world, dude? She's getting it, boy. Shit. Give her my own tunes. Yeah. Get it. What? We getting it, boy.
Amber is the color of your energy. I'm in love with a street.
There it is. There it is. Oh shit, that worked. Oh! Damn! Bam! Damn, that works too good. Shit! Okay. Wow. Yeah, that blew my mind.
Can be convicted of a criminal offense. And if sufficient evidence is not introduced on that, then of course the court must intervene as a matter of law. Now, People v. Burse, B-U-R-S-E, 62 Michigan 204, says also that a motion for a directed verdict is in effect a question presented to a trial court in the form of a motion as to whether or not there is sufficient real or circumstantial evidence as a matter of law from which a jury can reasonably infer all the elements of the crime charge. And more recently,
You never know what you're going to get at Publicly Buzzed, folks. We had to take just a little bit of a dance break.
Principles resound in the case of People v. Wolf, that's found at 440 Mich 508, where it's a 1992 decision where the court essentially reaffirmed the Hampton principles and the procedure that has been utilized by the Hampton decision. Now, quoting from the Hampton decision, when determining whether sufficient evidence has been presented to sustain a conviction, a court must review the evidence in the light most favorable to the prosecution and determine whether any rational trier of fact could find that the essential elements of the crime were proven beyond a reasonable doubt. Now, certainly, at this juncture and on this kind of motion, this court is prevented from making any kind of a ruling as to whether or not there's proof beyond a reasonable doubt. As indicated by the Hampton decision, the analysis has to do with whether or not there is sufficient evidence on the elements. Taken here, and I have not, I think, sufficiently constructed the elements from the statute, but I think that it's reasonable to utilize the statute itself in saying that. The statute says that a person who has knowledge that another person intends to commit or attempt to commit suicide and who intentionally does either of the following is guilty of criminal assistance to suicide. Subparagraph A provides the physical means by which the other person attempts or commits suicide or participate in a physical act by which the other person attempts or commits suicide. And then I should read into the record here because that will be a part of this in terms of the specific intent. Subparagraph 3 says that this does not apply to prescribing, dispensing, or administering medication or procedures if the intent is to relieve pain or discomfort and not to cause death, even if the medication or procedure may hasten or increase the risk of death. Now, the evidence must be looked at then in terms of what the elements are as to the Hampton principles of whether or not there is sufficient evidence on those elements. I should say here also that it must be shown that the offense happened on the date of August 4th and that it happened in the county of Wayne and or the city of Detroit. I am assuming that based on the arguments here that the element that would be in dispute here in terms of applying the Hampton principle is that of the venue. And weighing the evidence here, I look at what's already in the record. We have the police officer, Ms. Banks, testifying that she had seen the van on the island at a certain time, and more specifically that she spoke with the defendant, Dr. Kevorkian, on that particular morning, and he indicated something to the effect that he had been there approximately an hour and a half. Additionally, in terms of the being able to pinpoint the time of the death, the doctor did put it within a period of 1 hour to as much as, I think, 4 or 5 hours. In the tape itself of the interview that was done on August the 5th. Now, certainly there is no outright admission in that particular tape as to that this was done on Belle Isle or done in Detroit or in the county of Wayne. But I think that from the nature of the statements that were made, that the jury is allowed to consider, and a reasonable argument can be made that it may be just a normal reaction or a statement to say that, well, I did this at a a certain place and time, rather than comments that essentially give a sequence of events. I drove to Belle Isle. I gave provided the apparatus, and so forth. One could argue that, well, in a normal sense, one might say, well, I gave this to the person at a certain time, and then I drove to Belle Isle and so forth. And I'm not saying that I'm conclusively saying one way or the other whether or not I believe it happened one way or the other, but that those are classic issues for the trier of fact to look at in making that decision, because as a matter of law, I do not have to be concerned with whether or not those are true or not true, or whether or not the trier of fact believe or not believe them, but whether or not there is sufficient evidence in the record on those or that element for the juror to be able to make that decision. If this was a situation where there was certainly no proof in the record or no evidence in the record, then as a matter of law, it will be duty-bound to grant the request in order to avoid due process violations. But due process simply says that if there is sufficient evidence on that, viewed in the light most favorable to the prosecution, then the trier of fact has the right to make the further decision. And I rule hopefully inconsistent with that. All right, those are my statements in that regard. I understand the prosecution is formally resting. Mr. Feiger, would you be prepared now to go forward with any evidence you would? Okay. Then we can bring the group over. Okay. Go ahead. Get the group over, please.
Call them the group this time at least, instead of bodies. Can we get the bodies over here? I'm sorry, excuse me, sir. Who? The next one is 52 minutes, and it's neurologist Dr. Harold Clawens takes the stand. Let's see. Let's take a vote here. I'm going to put an actual poll in here. Do you guys want to go to one, or do you want to call it? Go to one or call it. One. Call it. Give me some votes here. You guys have the power. The power. My Nest cam up there. What's going on? I use that as like a weird transition cam. It used to be the old cam that I used actually for the show before I upgraded my camera. Let's see what we got here. Votes coming through. One's winning. Somebody wants to call it. Somebody's done for the day. Uh-oh. What is winning? One's still winning out of 6 votes. Boop, 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 boop. Give it just a second there. Thanks everyone for being here there. Really appreciate it. If you have not hit the like, please do so. Get this into the algorithm, which today's been pretty awesome, actually. It's been pretty good. 65 likes. Can't beat that. Everybody that's come through and donated, appreciate that. You guys are amazing. Please let me put this. I know it's already in there and it pops up randomly. But actually, I don't, maybe it's in there or the other way. But if you're using Amazon randomly, I don't know if that'll work or not. Use the link, the PubliclyBuzzed link, please. Yeah, use that link. That'll help us out on the back end. That's for you. Maybe if you got some last minute shopping you have to do, save that to your timeline or to your bar, not your timeline, to your toolbar up there. And then, hey, click that, portal into Amazon and get yourself something. And then on the back end, Amazon will be like, let's do it. Let's do it. Let's see, what do we got here? It looks like it's an astounding one. Let's keep rocking. Yeah, they're still coming through to one. It'd take a lot of votes. It looks like only one person's ready to call it, so let's go.
Yes.
Neurologist, Dr. Harold Clawens. I hope I'm pronouncing that right. It's a strange name. But a 52-minute video pretty much will take us right into 1 o'clock. Yeah, they're still coming in for one. We'll go on through here. Let's go, baby. We'll do a stinger as well. Love you guys.
The prosecution... Oh,
shit. Say no to globalism, taking us into one on a high note. 1999, passing the bowl. The plate and the bowl, excuse me. Yes, yes, and she has one of hers that I like to bring out as well. Hit her with one of these, first of all. Boom, thank you very much.
This is gun country.
This is gun country. This is gun country, baby. Thank you very much. Seriously, appreciate that. Love it. No, I'm not trying to dip. No, I want to leave it on y'all. No, I'm here. I'm here for it. Let's keep rocking. I ain't trying to go nowhere, Kaylin. I just want to see what everybody thought, because, I mean, I usually stop about 12:30, and this is going to take us on into 1. No, I'm good to rock and roll, baby. I'm ready to go. Let's go.
Always has the burden of proof in a criminal case, and that burden of proof never shift to the defense side at any time during the course of the trial. The defense is not obligated to prove anything, present any witnesses, or anything like that. I will inquire of Mr. Feigler, does he wish to go forward with evidence? Mr. Feigler, you wish to go forward?
Yes, Your Honor.
Okay, thank you.
Your Honor, at this time, I call Dr. Harold Klawans to the stand.
Klawans, I murdered it. Well, I don't even remember what I said, but it wasn't Klawans. Okay, Mr. Klawans, a neurologist. I apologize, sir.
Okay.
His name, the co-reporter, please, Doctor.
Harold Klawans, K-L-A-W-A-N-S.
Thank you. Raise your right hand, please. You do solemnly swear or affirm the testimony you're about to give in the matter now pending before this court shall be the truth?
I do.
Thank you. Please be seated.
May I proceed, Your Honor?
Yes, please do.
Thank you. Dr. Klawans, would you please state your name for the court and jury?
Harold Klawans,
And,
K-L-A-W-A-N-S.
And what profession do you practice, Doctor?
I am a physician, a neurologist.
And what is the practice of neurology, Dr. Klawans?
Neurology has to do with the medical diagnosis and medical treatment, anything that's other than surgery, of diseases of the nervous system, the brain, the spinal cord, the nerves, the muscles.
And where do you maintain that practice of neurology?
In Chicago.
Where?
I am at Rush Medical College, which is one of the medical colleges in Chicago.
And how long have you been practicing the specialty, the medical specialty of neurology?
26 years.
Do you maintain, in addition to your hospital practice, do you maintain a private practice?
Oh, yes, sir.
Is there a center in which you practice with other physicians?
Well, there's a what's called the Movement Disorder Center, which is one of the functions of Rush University, and I founded that in 1968, actually.
Where did you obtain your medical background, Doctor?
Well, I did my undergraduate work at the University of Michigan from 1955 to 1958. Then I went to medical school at the University of Illinois, graduating in 1962. I interned in Chicago at Presbyterian St. Luke's Hospital, and then did my training in neurology both at the University of Minnesota and back in Chicago.
And how long a period did you do your training post graduation from medical school in order to specialize?
3 years.
Are you board certified?
Oh, yes, sir.
What does it mean to be board certified in the subspecialty of neurology?
Well, the board is put together in part by groups of neurologists called the American Neurological Association and the American Medical Association, and it has two functions. One is to oversee the quality of residency training programs, and the second function of the board is to examine individual physicians. After you finished your training and you trained in a specialty, you then sit for an examination in which the board certifies whether or not you have learned sufficiently in order to be considered, quote, board certified in that specialty.
And how long have you practiced privately that specialty?
Since 1968.
And approximately how many patients do you see in your neurological practice, well, let's say presently, per day or per week, can you estimate?
Yeah, outpatients who see me in my outpatient office, I see probably about 50 return patients who I've seen previously and I'm treating on a long-term basis, and about 8 new patients, new referrals come from various sources each week. And then, of course, I see variable numbers in the hospital depending upon the weeks, but it can be anywhere from following 10 in the hospital at one time to seeing 30 or 40 in a week.
What type of neurological orders do you specialize in and or treat?
Well, I'm primarily interested in what's called movement disorders, the problems of motion, of mobility, of movement. Most common one that I deal with actually is Parkinson's disease.
Do you have occasion to treat, in your neurological practice, patients suffering from amyotrophic lateral sclerosis, or ALS?
Oh, yes.
What is ALS?
ALS is a disease of the primary motor control system. The primary motor control system is that part that starts in the brain here that generates the message of a movement you want to carry out. Then from this, what's called the motor cortex. That message then travels down in the spinal cord and goes to the nerve, which actually moves the muscle. If you wanted to move your thumb, that generated would start opposite side of the brain. The right thumb starts on the left brain. And if you wanted to move your thumb up, first this would generate here, would travel down to the spinal cord, and then a nerve here would send the message out to the muscle here, which actually moves the thumb. Now, ALS is a disease that involves both parts of that motor system. Both the part here that generates the original movement, that directs the movement, and the one that's what's called the final common pathway, the final way for...
I wish I could. I wish there was an option for that, actually. That'd be dope. Maybe I can jump through it. I am kind of interested in this part. I was kind of interested in hearing that.
Any message to get out of the nervous system and get to the muscles. This is often called the upper motor neuron, and the one in the spinal cord that comes out here is called the lower motor neuron. And there's some diseases, most strokes, for instance, just involve the upper motor neuron. People are paralyzed from a stroke, it's in the brain. If you could get the message to the spinal cord, everything would work. But ALS is a peculiar disease in that both the upper motor neuron is involved and the lower motor neuron is involved. So there is an inexorable progression of severe motor weakness at all areas involved.
And what's the final result of ALS?
It's uniformly fatal. Anywhere from 8 months to a year to sometimes quite longer. Usually the younger patients have a more rapid course. It's often called Lou Gehrig's disease. Lou Gehrig hit 340. The next year he couldn't hit, took himself out of the lineup, and he was dead about a year and a half later. So he was a fairly young man, rapidly progressive, not an unusual sequence in a younger patient.
Doctor, your curriculum indicates a number of academic appointments.
This one is an absolutely terrifying disease. Like, this one is horrifying. Your brain is still fully functional, like you know what's happening, but parts of it are disallowing or discontinuing the function of your muscles. Like, you're stuck inside of this inside of this body, right? Essentially, like your consciousness is stuck inside of this motionless bag of meat, and you're on your way out. Like, I cannot fathom taking a man to trial. And then the one that even put him in prison was also a Lou Gehrig's disease, with different circumstances, and he pushed it to the max, of course, killing the man himself, which he wanted to do, and the guy and the individual agreed, because he wanted to push the courts to the max to see, hey, we need to talk about this. But my Lord, this one is absolutely horrible.
Could you describe to us, what does it mean to have an academic appointment?
Well, I teach actively in a medical school. I lecture, do research, and carry out teaching in a medical school in Chicago.
Could you tell us some of your appointments? Your curriculum indicates appointments dating back to '68. Could you highlight some of those appointments for us?
Well, I've always taught at medical school. I'm presently a full professor both of neurology, we call it neurological sciences, but that's neurology, and pharmacology at Rush Medical College. And I have an endowed professorship, which means that people have put up money to assure that this professorship will always be for the study of Parkinson's disease. And I have that professorship at the medical school. Before that, I was a full professor at the University of Chicago before I was recruited to come to Rush.
How long have you been professing neurology in addition to your private practice?
Well, I've always been involved in teaching, first at the University of Illinois, then at University of Chicago, and now at Rush Medical College.
Have you also, in terms of your hospital appointments, had administrative appointments?
Oh, yes.
What have your administrative appointments been?
Well, for a number of years, I directed residency training programs. I was associate chairman of the department at Rush for about a decade. I was acting chairman for a number of years. I recently was asked again to be director of the residency for the last 3 years, so I've had a variety of academic roles.
Okay. What hospital appointments have you maintained besides Rush?
Well, actually, I'm just at Rush primarily the last 14 years. I've been a senior attending neurologist at Presbyterian St. Luke's Hospital in Chicago, which is the primary teaching hospital of Rush Medical College.
Your curriculum vitae also indicates hundreds of articles and books written by you. What subjects do those cover, Dr. Clewans?
Well, a wide variety of things. I've either written or edited over 50 books in the field of medicine, while many of them have to do with Parkinson's. 3 of those books are involved with motor system diseases, motor nerve diseases, and so it's a wide variety of subjects.
Have you written on recently in the area of Lou Gehrig's disease, ALS?
Well, the most recent publication was a volume of the Handbook of Clinical Neurology in 1991, yes, sir.
Okay. Doctor, your curriculum also indicates a number of editorial experiences with reference to learned medical treatises. What editorial positions have you maintained in terms of that? Just highlight a few.
Well, I'm editor-in-chief of a medical journal called Clinical Neuropharmacology, and I'm also one of the 3 editors of what's called the Handbook of Clinical Neurology. Most of us think of a handbook as a nice little book that sort of summarizes things. Unfortunately, the handbook comes from the German word. It means encyclopedia. And this is an encyclopedia of neurology, which is now in volume 64. And I've been the only American editor of it for the last, the other 2 editors are European, for the last 20 years.
Doctor, as lawyer, we all understand that briefs are rarely ever brief, so we can understand that.
Thank you, sir.
That's right. It's a contradiction in terms. Your curriculum also indicates that you refereed learned treatises or medical journals. What does it mean to referee a medical journal?
Well, when you're an editor of a journal, people write papers and they want to get them published, and they send them to you. And the editor can neither be the ultimate authority on everything in the world, nor really have the time to be the ultimate authority on everything in the world. So the editor's job is to know who would be the appropriate people to judge or referee this article. So the editor-in-chief's job is to send out the article to be refereed or judged by experts who would then give him, the editor-in-chief, their opinion on the value of this paper. The final decision rests with the editor-in-chief, but refereeing means that the editor-in-chief has entrusted you to give an opinion on whether or not this paper should be published in their journal.
And what journals have you participated in? Just general. I know your curriculum indicates
15 or 20.
15 or 20, but some we might have heard about.
Oh, Journal of the American Medical Association, the New England Journal of Medicine, almost all of the neurology and psychiatric journals in the world.
Your curriculum also indicates that you're a member of a number of societies. What medical societies are you a member of?
Well, I'm fellows of the 2 American neurological societies, the American
Kaylin coming through with the $5 holler, as Bob would say. Thank you very much. Thank you, Kaylin. Appreciate it. Money. Give you a little Holly Berry. Kaylin, thank you so much. I seriously appreciate the fuck out of that. That's amazing.
Neurological Society and the American Academy of Neurology.
Okay, deal. You don't have to twist my arm too hard there. I'll send you pics.
A number of international societies. I'm the head of a research group of the World Federation of Neurology. And I'm also an honorary member of the French Neurological Society, one of the few non-French speaking members.
Doctor, I've had marked as defendant's proposed Exhibit E a copy of your curriculum vitae, which lists
Something I'm going to have to film for you guys. This is going to be some extra content right here, where I'm always talking about getting extra content. So, like, it's raining here right now, and I just texted with Cassie because I was like, how's Gypsy doing what she's doing? And she's like, oh, it's raining. When it's raining and you try to let Gypsy out, like, Gypsy loves going outside. Like, Gypsy, like, you know what I mean? Like, it don't matter. She's pretty down with going outside. And she's even down with going outside with sprinkling. But if it's really raining, that's the only time. She loves snow. It's all good. But if it's really downpouring the rain, she will stick her head out, notice it's raining, and, like, nope the fuck out. She's like, nah, I'm good, actually. I'll just go lay back down. Like, after just freaking out to go out, she's like, no, I need to go right now. If I don't, I'm going to explode. I'm going to tear this out. You never know what's going to happen if you don't let me out right now, Dad. Sees that rain coming. Nope. She'd hold it the rest of the day. Like,
a number of the things we discussed, your education, your honors, your internship academic appointments, your administrative appointments, your society membership, journals, and hundreds of publications which you've written. Is this a true and accurate copy of that, of your qualifications and experience?
Yes, sir.
And did you provide that to me at my request?
Yes, sir.
Thank you. I'll let Mr. Kenny look at it, and I'll try to continue. Doctor, in preparation for your testimony today, were you asked to review certain tape recordings, videotapes, and documents with reference to Thomas Hyde and Dr. Kevorkian?
Yes, sir.
What did you review, if you recall?
Well, first I reviewed Thomas Hyde's medical records from Henry Ford Hospital, from the Muscular Dystrophy Association, the MDA-supported clinic. So a variety of medical records on Mr. Hyde. I also reviewed the videotape of Dr. Kevorkian and Mr. Hyde. I also reviewed, I think there was a videotape of a press conference with Dr. Kevorkian and a videotape of a TV program, Frontline.
Did those materials allow you to come to certain conclusions with regard to your experience and background and the medical condition from which Thomas Hyde suffered?
Oh, absolutely.
Doctor, could you tell the court and the jury, firstly, you've described, I think, in general terms what ALS is. Tell us how it progresses and ultimately kills a patient.
How it progresses depends upon how it starts. How it kills the patients is usually pretty much the same. Some patients, it starts primarily in the hands or the legs and remains mostly in the hands and legs. If that's the case, the patients have progressive difficulty with things involving their hands and legs and walking, getting up from a chair, using their hands, being able to write, being able to feed themselves, being able to carry out the kinds of things that you need your hands to, buttoning buttons, tying ties, zipping your pants, all of the things that involve, but a progressive weakness of the hands and legs. Patients with progressive weakness in the hands and legs, while they do get a great deal of disability, which can be very disabling within 2 to 4 years, you can't even get to the bathroom on your own, you can't transfer from a chair, and you can't roll over in bed, you can't do a lot of things that we normally all take for granted. We do all these things so simply. But their lives aren't terribly threatened by this disease. The part that threatens the life and causes death in patients with ALS is what we call bulbar. The bulb is the part of the brain back here that controls the muscles of the tongue and of the mouth and of swallowing and of breathing. And in the same way that when the muscles of the hands get weak and you can't write and you can't lift your hand, when the muscles of the bulb get weak, you can't talk, can't chew, can't move your tongue, can't swallow, can't even swallow your own secretions. You start having difficulty in chewing, in eating, in swallowing, in maintaining your own secretions, and to the point where the secretions collect in your mouth and you inhale them back into your own respiratory tract. Your muscles of respiration become weaker. Your cough ability to cough and clear your own spittle, clearing your own saliva becomes involved. And eventually, patients die either because they choke on food or they aspirate, breathe into the lung, pull into their lung their own saliva and have difficulty breathing, and get pneumonia and respiratory failure from this. Patients like this frequently, they can't even lie down on their back, because if they lie down on their back, saliva that collects in their mouth then starts draining into their lungs and they can't breathe. And they have these very weak but persistent coughs which don't really get anything done. It's a very agonizing, incredibly distressing phenomenon, both for the patient and everybody involved with the care of the patient.
What do you mean in terms of agonizing and distressing to both the patient and the caregiver?
There's no treatment. There is nothing we do that alters the course of this disease.
How about the brain or the mind of the patient? Is that affected
Patients
at all?
are absolutely aware and alert of everything. There is no change in mental function, no change in understanding, no change in anything else. It is a pure motor system disease. It's the only thing affected. The rest of the brain, it's sort of terrible to say, the rest of the brain, unfortunately, is functioning absolutely normally. The patient understands, recognizes, can see and tell everything. And there's nothing we can do about anything. It's, all the medical progress that we've made in this, the prognosis has changed from 18 months to a year and a half. I mean, in the 26 years I've been practicing medicine, there's nothing we've done that has changed anything, except occasionally people make the mistake of aggressively treating recurrent aspiration pneumonias and prolonging the agony in people's lives.
Why is this agony or suffering to resuscitate or to bring these patients back to life from aspiration or suffocation events?
When the patient aspirates, and this is an ongoing process, it's just going to happen again. There's nothing we can do to prevent it. The patient is suffering. Patient knows, patient is fully aware. In general these days, since almost all of these patients are cared for by people who are knowledgeable about the disease, the patient and the patient's family and the patient's caregivers and loved ones all understand what's going to happen. Patients almost invariably opt that I can't swallow anymore, but I don't want you to give me a stomach tube because the suffering will just go on. I don't want you to put a tube in my throat that'll allow you to clear things out when I can't, and make this process go on for a few more months, a few more weeks. So the patients almost invariably opt not to take these extraordinary extensions of their lives and recognize that there's nothing that can be done that they're going to die in this way, that life is becoming an increasing agony as they can do less and less for themselves, and this inevitable kind of slow death of choking on your own spit is going to come to pass. What unfortunately frequently happens is it's very easy for us to sit around and say, well, when it happens, it should happen. Many families, as dedicated as they are to the wishes of the patient, when that actually happens, scream, you have to do everything you have to save his life, and things sometimes get extended beyond that, and the next week everybody's unhappy that it was extended. We're not going to make that mistake again. Yet you do see those kinds of things done which just prolong people's agony a couple of times.
As a treater of patients with ALS and a diplomat of the American Board of Neurology and Psychiatry, how do you deal with the fact that a patient is mentally conscious of the way in which they are about to die? In other words, how do you deal with that terror and that form of suffering in the patient themselves? Do they request treatment? Are they drugged? What sort of things are available in terms of that treatment?
We, in general, do that relatively poorly in practice. I think probably the greatest benefit that most physicians give to most patients is an understanding of what's going on and a willingness to accept the patient's desires about not extending things, about not making things worse. If I come in with a terrible aspiration pneumonia and I'm turning blue and I'm already passed out and lost consciousness, don't do anything. Don't try to take extraordinary means to extend it.
Well, can you sedate these patients so that their terror, so that they're in sort of a twilight or a drugged-induced state in which their terror might be relieved?
The problem with that is that almost all the medications we have that would really be reliable to produce a degree of sedation in a patient with this disease will suppress respiration.
What does that mean in terms of giving a patient with ALS a medication that would cause tranquilization but impair respiration?
The easiest example would be whether frequently these patients are also in pain, they have cramps, they have spasms. Give them a little bit of morphine, get rid of the spasms, let them relax, let them get some sleep. They aren't getting enough oxygen to their brain. Such patients, our respiratory centers are extremely sensitive to morphine. So you even try to relieve their pain with a little bit of morphine, and you may well easily kill them.
Doctor, in the photographs that we've seen of Thomas Hyde, he complains of muscle spasms in addition to the suffering that you've described in detail. What's that all about?
That's involvement of the upper motor neuron. When the upper motor neuron is diseased, you get what we call spasticity. Most people with strokes have this. The arm is flexed in a spasm, kind of held like this after they recover from a stroke, and the leg on that side would be stiff. And patients with ALS frequently get spasms of this. And those spasms, called tonic spasms, can often be very, very painful. You review his medical records. Attempts, not very successful, were made to treat his spasticity with baclofen, which is one of the standard treatments of that, often not terribly successful in ALS, and also Valium. But of course, Valium, in enough to suppress the spasms, may well also suppress respiration to some degree. And also, Valium may suppress the cough reflex further, which makes clearing of secretions even harder.
It appeared as if he, according to his medical records, I want you to assume that he had been on Valium for quite some time, even as late as July of 1993 when that videotape was made. Why wasn't the Valium working since he was complaining and he had been on Valium?
Well, first of all, even in the best of circumstances, the treatments for tonic spasms and bad spasms in ALS are effective in a minority of patients. But once you have a patient who has severe bulbar problems, and if you look at the videotape of Mr. Hyde, he can hardly speak, so that the muscles of his respiration are involved. Saliva is collecting in his mouth. His tongue is small and atrophic and doesn't really work very well and doesn't move very well. So he's got terrible involvement, severe involvement of his bulb. I would suspect that his physicians are afraid to give him very high doses of much of anything that might have any effect on further altering his cough reflex, making him more sedated, decreasing the drive of his breathing centers. Those would all be extremely dangerous things.
You haven't discussed the functions of bowel and urine excretion. How are those affected in ALS patients?
Actually, motor control, the control of bowel and bladder, is usually retained quite long in the disease. On the other hand, you can't walk to the bathroom. You can't get there by yourself. You can't wipe yourself. it's the neurology books all simply say, well, it's well controlled. If you got enough help around to take care of it and do it, it is maintained. But it's only maintained with a
I wouldn't call that well controlled.
Great deal of wonderful care from other people.
Could you comment, Doctor, on, in terms of your review of the medical records, and then finally leading up to July 1st of 1993, approximately a month before his death, Thomas Hyde's medical condition and the progression of it as you saw it?
Oh, it's rapid.
Hold on just a minute before you respond. Go ahead, please.
His condition deteriorated quite rapidly. He had a rapidly progressive course. Not, as I said, the younger patients, who mostly are males, the younger males frequently will have a fairly rapid course. And the real determiner of the course is what gets involved when. The patients who, as we said, as it stays in the hands and the legs, go on for years. He had very early bulbar involvement. Once you have significant bulbar involvement, life expectancy is 6 to 9 months.
Could he be laid on his back for any length of time?
No.
Why?
Once he had that respiratory problem. He couldn't handle his own saliva. I wouldn't think he could.
What would happen?
Gravity would pull the saliva down. You lay on your back like this, saliva collects in the back of your mouth, some of it will get pulled down. You'll aspirate and get choked or get pneumonia.
He often would hold his head up in the videotape in an attempt to talk or perform some movement by extending the neck. Did you observe that condition?
Well, part of that is that may give him a little bit more respiratory control when he does that. Patients, depending upon no two patients are identical as to the rate of loss of muscle control in any one muscles. So they learn which muscles work best. And as a muscle gets weak, it may work better in one posture than in another. So that patients all learn tricks of posturing where they seem to be more comfortable.
In terms of any hope for cure of Thomas Hyde, what's your opinion within a reasonable degree of medical certainty as to his prognosis? At least insofar as you saw it in the medical records and the videotapes.
Oh, there was no hope for any cure. We have no cure for ALS. His prognosis was for severe progressive disability with increasing respiratory difficulties and death. Looking at the videotape, the medical record of the respiratory distress in July, who knows, 3 months.
I want you to assume that had he continued to survive, the next week the physicians had informed him and his family that they wished to place tubes into him for feeding. What's the purpose of doing that, if you know?
Well, in general, the purpose for a feeding tube is to maintain nutrition in a patient who's no longer able to swallow on his own.
How do you feed a patient prior to that time? In other words, what progresses up to the point in which you have to put a tube in them?
Tube is when patients can no longer swallow. It's not for feeding issue because you have to put the food in the tube or put the food in the mouth. It makes not much difference as far as caregivers go.
Well, prior to that time, is there a progressive problems in terms of swallowing or taking food down?
There's progressive swallowing difficulties. Patients go from a general diet to a mechanically soft diet to basically eating baby foods.
Do the patients have to be fed, or can they feed themselves?
Again, that depends on how much the hands are involved. His hands were severely involved, and I'm sure he had to be fed.
Doctor, in terms of your experience, which you've detailed to us, was there any method known to medical science that would in any way alleviate his pain and suffering other than the method employed by Dr. Kevorkian?
I know of no other method.
What was the effect of Dr. Kevorkian allowing Thomas Hyde to inhale carbon monoxide gas, assuming that occurred on August the 4th, 1993, in terms of the effect on his medical condition?
Well, it ended his agony. and suffering.
Had he not inhaled carbon monoxide gas on that date, would he have continued to suffer?
Yes, sir.
Up until what time?
None of us can predict, but weeks to months, at which point he would have finally choked on his own saliva.
In terms of your medical experience, are you familiar with other instances in which physicians prescribe either medications or perform procedures which are intended to alleviate suffering and nevertheless hasten or bring on death?
Yes, sir.
What types of situations are you aware of other than the one that we're involved with here?
Usually terminally ill patients, frequently cancer, other illnesses attendant with severe pain in which there is no appropriate medical treatment for the primary condition, and the patient's suffering will go on inexorably, often with a great deal of disability like Mr. Hyde had, not just pain, but lots of other disabilities. And frequently patients are just given increasing doses of narcotics.
What occurs?
They quit breathing.
What occurred in terms of was there, other than Thomas Hyde passing away, was there any other way to relieve his suffering?
Not that I'm aware of.
Thank you. I have no further questions at this time, and I would move for the admission of Dr. Kluwan's curriculum vitae.
Okay. Mr. Kenny?
No objection.
Okay, that's it.
Thank you.
I want to hold on to this for a second. Dr. Kluwan, you are, as a physician, familiar with carbon monoxide gas, I take it?
Oh, yes, sir.
And would you consider carbon monoxide gas a poison?
Yes, sir.
Would you consider it a medication that you would prescribe as a physician?
That I would know, sir.
In fact, I believe you, if I understand this correctly, you received your medical degree in 1962.
That's correct.
From 1962 until today's date, have you ever prescribed carbon monoxide gas as a pain reliever?
No, sir.
Would it be fair to say that if you were, strike that, you are familiar, I take it, as a physician with seeing patients or individuals who have been exposed to non-lethal amounts of carbon monoxide?
Well, we're all exposed to non-lethal amounts of carbon monoxide every day of our life, depending on where we live.
Okay.
But I've also treated patients for carbon monoxide induced medical conditions. Yes, sir.
Okay. Fair enough. Let me clarify the question. In terms of someone who's been exposed to carbon monoxide and they're not dead, yet it requires them to come in contact with you as a physician in your professional capacity.
Yes, sir.
Such as in an emergency room or whatnot. When you see people in an emergency room who have been exposed to carbon monoxide gas in a non-lethal form, what's the impact that it has on people physiologically?
I mean, how does carbon monoxide work on the individual patient?
Yes.
Carbon monoxide binds with hemoglobin. Hemoglobin carries oxygen to your nervous system. Carbon monoxide binds with the hemoglobin and displaces the oxygen, so that instead of oxygen reaching the brain, carbon monoxide reaches the brain with the hemoglobin. And it is the lack of oxygen in the brain that causes the patient to lose consciousness and then to expire.
People who come to an emergency room, if they have been exposed to carbon monoxide, do you give them any type of medical treatment or anything to help them?
Yes, sir.
And what do you do?
Well, they're given oxygen. Sometimes they're even given hyperbaric oxygen.
What does that mean, hyperbaric oxygen?
Hyperbaric oxygen, excuse me. Being technical. You give them oxygen under increased atmospheric pressure, greater pressure than this, so that more oxygen would go into the blood and more quickly get up to the brain to relieve the oxygen deficit.
Okay. And all of that, I take it, would be with the intention of eliminating or dissipating the carbon monoxide that would be in someone's system. Is that fair?
Sir. Yes, sir.
When you teach at the medical college, do you ever teach any of your medical students or medical residents to utilize carbon monoxide as a treatment for pain or suffering?
No, sir.
And why is that, sir?
Well, I don't think anyone's ever tested it under those circumstances. It's a...
Now, you've indicated to us that with regards to someone who is suffering from ALS and has the muscle cramping, that intervention is made to try to relieve the suffering, to relieve the cramping, but that it's only successful in a minority of cases. Did I hear you correctly?
Yes, sir.
Is there any particular treatment of choice that's used in terms of, once again, asking you to think back in your capacity as a medical school professor, in terms of what you might advise or teach residents or medical students to utilize as the most effective treatment of choice to relieve the pain or discomfort of muscle cramping?
Two of the medicines, I think I mentioned them before, that Mr. Hyde was on, the Leorisol or Baclofen. Those are two names for the same medicine, which he was on, and Valium.
And are both of those drug treatments that have the potential of causing an ALS patient's respiratory condition to possibly become worse?
Yes, especially the Valium, yes, sir.
Okay. So if we're looking at something like Valium, we're talking about basically there's a potential upside, but there's also a downside to prescribing Valium, correct? In that, in a minority of cases, the pain of muscle cramping could in fact be addressed. The downside being it could make it harder for that particular ALS patient to breathe. Is that fair?
Absolutely. All medications are, the selection of medication is always weighing of risks and benefits. It's a risk-benefit choice, selection.
During the course of your dealing with patients who have ALS and have problems of muscle cramping, do you ever, or do you confer with them, talk with them, and ask them if they're willing to run that risk, if you will?
Well, it's always part of the discussion when you give medications.
Would it be fair to say that in some instances, the risk of someone having breathing problems by taking Valium could be greater than with other patients?
Oh, yeah.
Specifically with someone like Thomas Hyde, in terms of giving him Valium, if the Valium were not working, would it be conceivable that a treating physician could go to someone like Thomas Hyde and say, excuse me, Mr. Hyde, since the present dosage of Valium is not working, we may try to increase the dosage in hopes of addressing the cramping pain. But you need to know, Mr. Hyde, that if we increase this dosage, it may pose some real respiratory problems for you, and maybe your muscle cramping problem won't go away, and you may even die. Can that happen? Is that something that could happen?
Certainly can.
Okay. I believe you indicated toward the close of your direct examination in response to questions from Mr. Feiger that with regards to those who are terminally ill, their suffering risk may be addressed by increasing doses of narcotics. Is that correct?
Yes, sir.
Would it be fair to say that with cancer patients, for example, if someone is being given increasing doses of painkillers, there comes a point where it becomes a toss-up or a question as to whether or not someone may be able to get a benefit from the painkiller as opposed to dying?
That's assuming that benefit and dying are two opposite things, but yes, sir.
Okay. Now, Doctor, let me ask you a little bit about neurology. You've indicated that you got that, you specialized in neurology when you were at the University of Minnesota?
1 year at Minnesota, 2 years at Illinois. Yes, sir.
And I believe you also then talked about becoming board certified.
Yes, sir.
And can you tell us, please, why is it important for someone who works in the field of neurology, or anyone, strike that, why is it important for anyone who is a medical doctor to seek something like a board certification?
Well, in the specialties, it's sort of a recognition that you have successfully completed your training in the eyes of your peers.
Okay. And recognizing that you have, in fact, specialized in dealing with that particular area of medicine. Is that correct?
Correct.
And achieved a degree of mastery?
Reasonably so, yes, sir.
And would you say that in terms of diagnosing and working with those who suffer from ALS, that is left to the specialty of neurologists?
Pretty much so these days.
You would say, would you not, that in this day and age, that if someone were diagnosed with ALS, that most physicians, internists, if you will, would refer a patient to a neurologist as opposed to continuing to treat a patient who was so afflicted?
In general, I would say yes.
Doctor, were you familiar with the autopsy that was done in this particular case on Thomas Hyde?
Yes, sir.
Did you see, sir, that Thomas Hyde had an 88% concentration of carbon monoxide in his blood and urine at the time of the autopsy?
Yes, sir.
you would certainly agree that that would be a lethal dose of carbon monoxide, would you not?
Yes, sir.
Would you or do you consider carbon monoxide a medication?
No, sir, not in the usual sense.
And that's because you consider it a poison, is that right?
Well, that's not true. I mean, there are other poisons that are also considered medication. So the mere fact that something is poisonous does not mean it cannot, under some circumstances, be used as a medication. We use, in our office, we use one of the deadliest poisons in the world, botulinum toxin, as a treatment for neurologic disease in 20 to 40 patients a week. So the mere fact that something in some circumstances is a poison is not the reason. There is no body of evidence I'm aware of a general usefulness of carbon monoxide would be my reason, not because in most circumstances it's toxic.
Okay. Thank you. Nothing further.
Okay, before you do that, go further. I think the court reporter would need some help in that one.
Oh, botulinum toxin, B-O-T-U-L-I-N-A.
Okay, go ahead, Mr. Frank.
Thank you. Doctor, just following up a few questions Mr. Kenny asked you. With the very best of care and under the very best of circumstances, could you have done a better job treating Thomas Hyde's medical suffering than Dr. Kevorkian?
Well, I couldn't have done anything for his suffering. I mean, there's nothing more, there's nothing that I know of that I could have done for him short of suppressing his respiration that would have given him relief.
If you had suppressed his respiration through the administration of too much Valium rather than carbon monoxide, would the ends have been the same?
I would have been just as dead, yes, sir.
In this case, was benefit and dying two separate things? You mentioned to Mr. Kenny, that's assuming they're two separate things. In this case, was there any benefit or relief of suffering attainable by Thomas Hyde other than dying?
Certainly terminated his suffering, yes, sir.
If he had continued to live, would he have continued to suffer?
Yes, sir.
Other than him going to sleep and passing away through the use of carbon monoxide, had that not happened, what would have happened to him in your opinion, Doctor?
He would have eventually aspirated and choked on his own saliva, either gotten a pneumonia or choked and had a respiratory arrest.
Therefore, did the use of the carbon monoxide have the effect of relieving his suffering?
Well, I'm going to object. That's a legal question, Judge, for the jury to consider.
No, I'm not asking him legally. I'm asking him medically, Your Honor.
Just phrase that for me again in here.
As a matter of medical, or just as a matter of fact, did the ingestion of carbon monoxide in this case have the effect of relieving Thomas Hyde's suffering, in your opinion?
Answer that, please. Go ahead.
Thank you.
Yes, sir.
All right.
I mean, come on, like...
When Christian Barnard did the heart transplants, had they ever been done before by anybody else?
No, sir.
When Dr. Forsman first performed...
I'm going to object at this point, Your Honor, as to relevancy. And also, I believe this is argumentative.
You want to respond to that briefly?
Yes, I think Mr. Kenny was trying to go into accepted medical procedures versus procedures which have been utilized and later adopted by the great majority of the medical profession, and that's what I was going into, since Mr. Kenny seemed to believe that only what's accepted now will in medicine might be what's accepted for all time and never change.
Okay. Response, Mr. Kenny? Any response?
Same response, Judge.
Okay, I'm going to obtain the objection, Mr. Frank. I think it's a bit beyond that, please. Okay, go ahead.
Okay. In terms of traditional forms of treatment of Thomas Hyde, had all of those, in your opinion, forms in attempts to otherwise alleviate his suffering been exhausted, Doctor?
Yes, sir. Absolutely.
Finally, in terms of your viewing of the tape and also your understanding of Thomas Hyde, did he appear to you to be mentally competent?
Oh, yes, sir.
Thank you, Doctor. I have no further questions.
Kenny?
Thank you.
May Dr. Klawans be excused, Your Honor?
I'm sorry, you had a question?
Yes, I do.
Oh, I'm sorry.
Okay, proceed.
Doctor, did I understand you correctly to say that you believed that nothing else could be done for Thomas Hyde short of, and I think you said, suppressing his respiration?
There was nothing that, I think the question was, there anything I could do to relieve his suffering, and I said nothing that wouldn't suppress his respiration. Yes, sir.
So it would be your testimony that anything to be done to deal with his suffering would kill him?
All probability, yes, sir. Certainly would have a likelihood to.
And when you use the term
You're arguing that this man should suffer more, sir. I mean,
suppressing respiration, just so that we're all clear, we're talking about death. Is that right?
Yes, sir.
Nothing further.
Mr. Feiger?
Did carbon monoxide suppress his respiration?
Yes, sir.
Thank you.
Any other questions of the doctor?
No, thank you, Your Honor.
Thank you, doctor. You may be excused. All right. You have someone else, Mr. Feiger?
Yes, I do, Your Honor. This time I call I call Sean Hyde to the stand.
Okay.
all right, this is where we'll start off next week, everybody. And we'll keep rolling through. A great morning into afternoon. Thank you all for hanging out so much. Appreciate it. MJ coming through right at the end. Lurkers, fuck the world. Okay, that's how I've always known that to be known. Okay, fuck the world. I've never heard of this. I don't even know what the other way was. It is fuck the world. Okay, what was the other way? I've literally done forgotten. So let me give her a little love. We'll give some Holly Berry. Love you, MJ, coming through here lurking like a queen, huh? Boom. Love you. Thank you so much. Seriously, appreciate it. Everybody that came through this morning, you guys are amazing. Yeah. What a cool morning. At 1:30 p.m. Eastern time, it looks like Jessica for Justice is going to go live on Kick. Go check her out. I think I've still got this. So you can go straight there. Next time you'll see me will be Tuesday. I'm thinking Tuesday night on Kick. Maybe we'll start Twin Peaks at the beginning and see what happens. Keep eyes on Twitter, on YouTube community, on Facebook. I hate Facebook, but I still post there. Everybody, oh my God, everybody came through the day and donated. Gypsy, thanks to you. I thank you. Thank you guys so much. You're amazing. All the new people that are hanging out, following, absolutely amazing. Please, turn on notifications. Turn the bell on. Make sure you get notified today or even go back and check it out later this evening because the Bryce Rhodes trial that's starting this week, I'm going to be all over that. I'm going to be checking that out. I'm super intrigued by it. Dropping a video tonight. You're going to find out exactly why this guy could potentially be in something called a shock cuff. Okay? So please check that out, guys. JBN tonight, 7, I think it was, 7. That you're actually getting portaled out of this into that. I think it's on both channels, but big announcement. We're going to find out what happens between the JBN and the J channel. Love everybody, man. Thank you guys so much. Let's do it. Love you guys. Portal it up.